Order, please. Excuse me. I'd like to call the meeting of the Law Amendments Committee to order. My name is Keith Irving. I'm the MLA for King South, and I'm also the Vice Chair of this Law Amendments Committee. And I'd like to welcome all the members of the public for joining us here this evening to participate in the democratic process as we as legislators work on the bills before the House. So I'd like to begin by having my colleagues at the table introduce themselves, and perhaps we could begin by Ms. Martin.
Thank you, Tammy Martin, MLA, Cape Breton Centre.
Good evening, I'm Claudia Chender, MLA for Dartmouth South.
Good evening, Tory Rushton, Cumberland South.
Good evening, I'm Barbara Adams, the MLA for Cole Harbour Eastern Passage.
Hello, bonjour, Ben Jessam, Hammonds Plains, Lucasville.
Hi, I'm Margaret Miller, the MLA for Hands East.
Hello, bonjour, and welcome to tonight. Rafa Di Costanzo from Clayton Park West, MLA Clayton Park West.
Good evening, MLA Suzanne Lonis-Croft, Lunenburg.
And I'm joined on my right by Karen Kinsley, on my left by Philip Grassi from Wedge Council to assist us in the proceedings this evening. So I just want to run through the rules and how this committee, how things will unfold this evening. Most important thing, washrooms can be found down the stairs, and just make a U-turn at the bottom of the stairs to your left. In case of an emergency, you'll exit on the Granville Street side and meet at Parade Square. Photos are only permitted by accredited media, so no photos or video to be taken during the proceedings here. With respect to presentations, and we've got quite a few this evening, we have 15 minutes per presentation, and we usually divide that up in 10 minutes for a presentation and 5 minutes for members to ask questions. You can be shorter or longer at your discretion, those that are presenting. I'll do my best to give you a 2-minute warning when you're coming to 10. And as I say, if you want to go over 10, I'll let you know when 10 is, and you can proceed as you wish. But I will be a bit of a taskmaster with respect to time to ensure that we get everybody to the table and home before midnight. No props are permitted under the rules of the legislature, and it's important that you wait to be recognized by myself, the chair. That goes for my colleagues around the table. This helps with respect to Hansard and ensuring that we attribute people's comments to the correct person. As well tonight, je comprends qu'il y a des gens peut-être qui veulent parler français, faire des présentations en français. Nous avons des services de translation. So for my colleagues here, you can plug this in, and for members at the speakers here, can plug on the left or right of the mic. Oh, I'm learning myself. At the bottom, left or right, and if you plug it in on the right, then you use the controls on the right. If you plug it in the left, use the controls on the left. The top button is between 0 and 1, so 0 will be what is being spoken in the room, and if you need the translation, you move over to 1. And then the volume up and down is just below that. Any questions on the translation? I'm sure we'll all get the hang of it. So with that, we have, is it 6 bills? 5 bills to deal with tonight. There is one without representation, so I'm wondering if I could have a motion, please. Ms. Di Costanzo.
Sure. Thank you, Chair. I move that Bill number 177, the Public Utilities Act amended, to be moved back to the House without amendments.
Any discussion? All in favor, please signify by saying aye. Motion, opposed? Motion's carried. Thank you. Mr. Jessup, do you have a question?
I'm just noting that there's no French translation presently, or is that only?
Yeah, so I think it's when we have a presentation en français that we would.
Okay. Yep. Thank you.
Thank you. So first bill we will deal with I guess it's coming up later as well, but we're the Expropriations Act, Bill number 169. John Travis from Halifax Regional Municipality. Welcome, Mr. Travis. The floor is yours.
Thank you, Mr. Vice Chair and members of the committee. My name is John Traves, and I am the Director of Legal, Municipal Clerk, and External Affairs with the Halifax Regional Municipality, or Municipal Solicitor, if you prefer. I have 15 copies of my remarks tonight, and I will be brief. I appreciate the opportunity to speak in support of Bill 169, an act to amend Chapter 156 of the Revised Statutes 1989, the Expropriation Act. HRM supports this bill, in particular the government's goals around clarifying that one of the purposes of the Expropriation Act, and in fact I think one of the key purposes of the Act, is for people impacted by expropriation to be reasonably compensated. As you may be aware, HRM is an expropriating authority both on its own and on Halifax Water's behalf. Having acted in expropriation matters for many years, first with the province and now with HRM, I can tell you from firsthand experience that expropriation is difficult for all involved, however, none more so than landowners who are directly impacted. Expropriation is not undertaken lightly, given the reality that we are forcing property owners to put the public need for their property ahead of their own personal interests. The clarity this bill brings is important because without a clear understanding of reasonable compensation, we often see uncertainty and expectations, both by the expropriating authority and property owners, which leads to more stress, to problems, and litigation more than is necessary or helpful in the circumstances. We're also supportive of the administrative changes that would see cases for injurious affection without a taking dealt with by the Supreme Court rather than the UARB. Like most administrative tribunals, the UARB has experience and expertise in a lot of areas where it brings these to bear, and generally in assessing property values in expropriation cases. However, in these limited expropriation cases, the claim is essentially a form of nuisance claim. And moving this to the Supreme Court, we believe, will result in a more consistent treatment of these sorts of claims generally. Expropriation is and should be costly for expropriation authorities. You know, it is the alternative to a negotiated purchase or an alternative route or approach in these circumstances. But as Minister Furey has said at second reading, infrastructure investments are a priority. To help advance these priorities, the expropriation process needs to provide landowners with a fair and reasonable compensation while balancing the interests of taxpayers, ensuring responsible fiscal management and providing more clarity for all concerned. Thank you for the opportunity to speak tonight.
Thank you, Mr. Travis. Any questions from the committee? Ms. Gender?
Thank you for your presentation. One of the questions that we've heard, and I'm really interested in your take on this as the municipal solicitor, is whether I guess it's a two-part question. One is, do you see any potential access to justice issue with moving the venue from the URIRB to the Supreme Court, where the Supreme Court is a more difficult venue to access and more costly? And you say here you're supportive of those changes for consistency reasons, and I'm wondering if you've seen inconsistency in decisions from the UARB. Mr.
Travis.
Far be it from me to criticize the UARB. There is a different level of expertise and experience at the Supreme Court level. I think, particularly in the past number of years, the appointments to the bench have been superior, frankly. And so, I would certainly see for these sorts of cases a better understanding of the issues in the law. And that's not, and I don't mean that in any way to denigrate the UARB. They are very, competent, and they bring a lot to the table. To your point in terms of access to justice and more costs are more difficult to approach, that's not my experience. Administrative tribunals these days have the same obligations with respect to, fairness and just results. The processes are in many cases as long as they are in the court process. And the costs are roughly the same, frankly. When you look at having to engage a lawyer to bring a case in front of the UARB, you're seeing those costs and the time involved, about the same. I'm looking now at booking UARB matters some point next year. It's not much different than booking matters for Supreme Court, frankly. What I do see in the Supreme Court is you have access to a process which has settlement conferences. You have the jurisdictional, the rules of court, which in many ways assist the parties in getting to a resolution faster. So I actually think it's better in many instances. The UARB has definitely a place which is, around those areas of expertise, particularly on oil and gas and other matters, which I think our courts could get up to speed on, but they do bring in expertise, the same as most administrative tribunals. You're welcome.
No further questions. Thank you, Mr. Travis. Oh, I'm sorry. Ms. Lonis-Groth.
Thank you. My colleague and I were just reasonable compensation. Is that through appraisal?
Mr. Travis?
Generally speaking, that's through an appraisal process, yes. At highest and best use in most cases in terms of the property involved.
Any further questions? Thank you, Mr. Travis.
Thank you very much.
Speaking to Bill number 175, Colin Sproul. Can we restart that? Mr. Sproul, please go ahead.
Committee members, Vice Chair, thank you for this opportunity. My name is Colin Sproul. I'm the president of the Bay of Fundy Inshore Fishermen's Association and the president of the Southwest Lobster Science Society. I sit here before you tonight incredulous that the Bay of Fundy Inshore Fishermen's Association has not been consulted on the passing of the Marine Renewable-energy Act or tonight's proposed amendments. Our concerns are well known to the government, and we cannot fathom how the consultation process bypassed us for the amendments or for the Act. But tonight I'll speak to the specific amendments. Subsection 1 of the amendments attempts to remove the term demonstration permit from the Act and from the description of what's taking place at the Fundy Ocean Research Center for Energy. The original intent of the EA for this site was for a small-scale 5-megawatt tidal energy test station, and any attempt to remove the word demonstration from the Act countermines that process. Subsection 2, the minister shall prescribe the form of a power purchase agreement. The minister, having discretion over power purchase agreements, ignores the scope of the environmental assessment and underlines the role of the Utility and Review Board within Nova Scotia, who has already acted with an across the board for all ratepayers increase to finance tidal energy development in Nova Scotia. Subsection 3, the aggregate nameplate capacity allowable under the cumulative power purchase agreements. This proposed change to the Marine Renewable-energy Act is designed to undermine the original intent of the EA for the Fundy Ocean Research Center for Energy, which is that it was specifically stated in the original power purchase agreements and the EA that no duplicate technology would be allowed on the site. This was intended to be a test site to develop competing technologies to determine which one would be the most beneficial for generating power and the least effects on the environment. There are already 2 berth sites at the Force site that have been combined and 2 more slated for combining with duplicate technology on the berths, further undermining the original EA and the intent of the government on the process. Subsection 4, the public utility shall procure all electricity under the power purchase agreement at a price to be determined by the minister and set out in the agreement or agreements. How can the Minister of Mines and Energy set the price on power in Nova Scotia? That's the role of the URB. And it is once again, it is already approved an across-the-board rate increase for the feed-in tariffs for the existing purchase power agreements. Subsection 5. The license holder and the public utility may, by mutual consent, amend the purchase power agreement at any time, further ignoring the role of the URB within Nova Scotia. Subsection 6, the Utility and Review Board shall allow a public utility to recover the costs in connection with any power purchase agreement in Nova Scotia. The nitty-gritty of that subsection is this. Developers will face 0 financial risk in the Minas Passage. Emera cannot lose. Nova Scotia takes 100% of the risk on all of these, be it ratepayers or fishers. Subsection 7. The term of a power purchase agreement referred to in the subsection ends 15 years after the commercial operation date. The original environmental assessment, which allowed the start of the Fundy Ocean Research Center for Energy test site, all science that took place was carried out on the premise of a 5 megawatt, 5-year-long, small-scale tidal energy test facility. Since then, that evolved to 6 years with no documentation, and now this current amendment to the Marine Renewable-energy Act will push the power purchase agreements to 15 years, still based on the original 5-year federal environmental assessment. The original agreements were based on from the dates that the lease site became available, not the dates that generation started, which further pushes the term again. This is incredibly beyond the scope of the original environmental assessment. Number 8, no power purchase agreement may be entered to in this section after December 31st, 2021. All Nova Scotians must ask themselves, why is the government seeking to limit new, possibly less harmful, or more competitive technology from the forced demonstration site? What possible benefit is there to Nova Scotia and Nova Scotians from subsection 8? Emerging industries and emerging technologies in tidal energy generation like Big Moon Power are generating power now in Nova Scotia at 1/5 of the capital cost of turbine-generated power. What possible benefit is there to exclude technologies such as these from our test site in Nova Scotia? The Offshore Energy Research Association, the quasi-regulator for and developer for tidal energy within Nova Scotia, is now headed by the former leader of Open Hydro Canada, the very man responsible for the bad faith installation of 1,000 tons of garbage on our prime fishing grounds. How dare this government put this man into a quasi-leadership role and a quasi-regulatory role? All of these amendments seek to do one thing: stretch the scope of the original intent of Fundy Ocean Research Center for Energy, further creating even more risk to my members, while still failing to deliver competitive, ecologically generated tidal power for Nova Scotia. Thank you. I invite your questions.
Thank you, Mr. Sproul. Any questions from members? No questions? Thank you, Mr. Sproul. Next is Jason Heyman. Mr. Heyman, you have some documents to circulate?
Yes, I do.
Oh, we'll get a page to hand that around.
Right, thank you.
Welcome, Mr. Heyman. The floor is yours.
Thank you. So my name's Jason Heyman. I'm the Managing Director of Sustainable Marine Energy, a tidal energy technology and developer here in Nova Scotia, here to speak in support of the amendments to Bill 175. And I suppose here to tell you that the tidal energy industry is alive and well in Nova Scotia, and we have the only operational tidal energy, in-stream tidal energy system in Canada, currently installed in Nova Scotia waters. And just to maybe just correct something, we have come to Nova Scotia, I suppose invested very heavily in Nova Scotia over the past years on the basis of the prize of the Bay of Fundy in terms of its resource, the economic prize, and that has very much been stood up by the 15-year PPAs, which they have been for quite some time now at 53 cents. We operate turnkey tidal energy systems. The one you see here is located down in Grand Passage. We've been around since 2012, and one of our largest shareholders is a German company called Tidal, and they've been active here under BRTP since 2014 when they were first awarded a berth at Force. Previously, they invested over $10 million here locally in a first technology that didn't fly. Now they're having to mull again, and we've dropped a similar amount of money in the last year. So that shows you what the sort of economic prize is of developing these technologies, and not everything is going to win, and it does take time. We have 21 staff worldwide. 11 of those are here in Halifax. So we have two projects, a demonstration project, which is not grid connected, down in Grand Passage and Digby Neck. And we have a project that we are developing at Force. And we have teamed up with another berth holder there to create a 9-megawatt project, because that is very clearly what the federal government of Canada has stated that it wants and has offered support for. As you see here, we've been developing this for quite some time. We've been in the game for a while, and we can see here that our operations in Canada. So we have our headquarters here in Halifax. We have our test site at Grand Passage, where we also have an operational basin team, and then Force is where we're developing our first demonstration project. We brought our platform over here over a year ago, used local yards on the Matagan Shore, AF Terrio, to assemble our device. We use local contractors such as Hubley Subaqueous Construction, both to install it and maintain it. And we have gone through our first winter in Canada successfully, survived an altercation with a lobster boat, and rode through Hurricane Dorian. So we're well on the path to proving that our technology is viable. We've also done extensive environmental monitoring. In fact, I just came from a workshop with Department of Fisheries and Oceans and NSDEM and NSE, where we've been talking about exactly the environmental issues, and we've been given an all clear by DFO on our first deployment at Grand Passage, where we monitored the turbines with cameras and no serious or harmful impacts to marine life were recorded. And we will continue to monitor and develop in a successful manner. Or in a, responsible manner, hopefully successfully too. In terms of our commercialization journey, what we see is it's very important to be able to walk this journey step by step, and the amendments that are proposed basically provide us with the opportunity to do that, because they take away the hard cliff edge timelines, which are currently attached to the PPAs, which drive unintended consequences of behavior, and we need to be able to develop as and when we are comfortable with the technology, we're comfortable with the environmental results, and of course can attract the investment and work to get our costs down. And that's where I suppose a demonstration project or site at Force is really important. It is a test site, and you've got to be able to do things multiple times and put multiple pieces of equipment in the water to do the learning to get down the cost curve. And then you'll probably end up with something, or hopefully end up with something, which is actually competitive with incumbent technologies. And that's the objective of the Force site. And we see that that journey is particularly important, and Nova Scotia has a fantastic opportunity at the moment, largely because of the political chaos that reigns in the UK, where most of this industry has been incubated and are now looking to come here into what is one of the best resources in the world to develop that. In terms of our actual project, we're looking to develop it in phases through 21, 22, and 20, and hopefully into 23. What we need to be able to pool the sort of investment that's required to develop a project this size, we're talking in the order of $100 million. If all the sites were developed at Force, we are talking sort of $200 to $300 million of inward investment into Nova Scotia. Most of our investment is coming from foreign investors and foreign companies like Tidal, our parent company, as well as German financiers Reconcept. And there is federal public funding support coming, but of course that's inward investment into the province as well. So what we see here is that this is a chance for Nova Scotia to firmly plant itself as a leader in this field, provide the right environment to incubate this industry, attract a lot of inward investment, create a lot of jobs. And the reality is there is no risk, because developers only get paid upon results. So you only get paid for the electricity that you produce when you deliver the goods. And by then, you will have had to invest tens, if not hundreds of millions of dollars to get to that point. Thank you.
Thank you, Mr. Heyman. Questions from the committee? Great. Thank you very much. Picking up a bit of time here, I'm hoping that Harry Critchley and Hannah Garson are here. Terrific. Okay, we'll move now to some presenters on Bill number 180, the Fatality Investigations Act. If you have presentations you want to circulate, our page can help us out there. Okay. Welcome, Mr. Critchley and Ms. Garson. Floor is yours.
Committee, we're here on behalf of the East Coast Prison Justice Society. So we're a society that acts as a hub for prison justice advocacy in the Maritimes. And the mandate of our organization is to coordinate research and data collection, legal support and advocacy, education, and service provision efforts for prisoners in the Maritimes with a view towards systemic improvements in our correctional facilities. We want to begin by thanking the government for bringing in these proposed amendments establishing a Child Death Review Committee and a Domestic Violence Death Review Committee. As Minister Fury has stated, these amendments are intended to prevent future deaths, and they are informed by a conviction that one intimate partner death or one death of a child in care is one too many. That said, in our view and in the view of our organization, so too is one adult death in custody one too many. However, according to recent research, in the last 8 years, 12 people have died in jails and prisons here in the province. With that in mind, we propose 3 changes to the amendments which will enable them to more effectively achieve their stated goal. First, we argue for the establishment of a parallel death review committee, hereafter DRC, for adult deaths in custody. Second, we argue that DRCs need to be provided with statutory powers to ensure that they have capacities to truth find, meaning that they can be more than simply rubber stamps on internal investigations. And we also need provisions requiring that their findings and recommendations be made public. Finally, we need to ensure that these reviews into death are mandatory, like in virtually every other province in Canada outside the Maritimes, and we need to build accountability mechanisms into the Act. In determining to whether to pass this bill, such important details cannot be left to the regulations. Without including these details in the Act, the proposed amendments leave the scope and procedure of the review process underdetermined and thus open to be decided on in a much less public forum. So first, the need for a dedicated adult review and custody review committee. Nova Scotia needs to establish a parallel DRC for adult deaths in custody. By in custody, we mean places where people are detained or cannot leave at will, including in police lockups, correctional facilities, both provincial and federal, forensic psychiatric hospitals, civil psychiatric hospitals, as well as to institutions under the Home for Special Care Act and its regulations that impose restrictive conditions on residents, including locked wards, confinement in locked cells, and other physical and medical restraints. Liberty restrictions in such places can enable friction, conflict, and violence and other forms of abuse, which may be shielded by clinical cover or institutional secrecy. Failing to establish a standing adult death in custody review committee under the Act will further impede the exercise of discretion currently required to bring about a fulsome review of an adult death in custody. Section 39B of the amendments gives the Minister, in consultation with the Chief Medical Examiner, the discretion to establish other ad hoc death review committees. This is not a departure from the status quo. Currently, there is discretion left to the Chief Medical Examiner and/or the Minister as to whether to convene a public inquiry led by a provincial court judge. Historically, that discretion has been used very rarely. Where there is no inquiry, there is also no provision in our legislation requiring that reasons be given as to why not to hold an inquiry. When people die in custody, there are often more questions than answers. Consider the recent death of Greg Hiles at the East Coast Forensic Hospital. His incarceration was indefinite, and his release dependent on determination that he was mentally well. Greg Hiles claimed that his prolonged placement in restrictive conditions, a placement decision which Justice Anne Smith called procedurally unfair and lacking in an evidentiary foundation, was worsening his mental health, and he and 3 others instituted legal proceedings via an ultimately unsuccessful habeas corpus applications. All this gives us reason to want to know more about the circumstances leading up to and surrounding Greg Hiles' death.
I will now review the 2 remaining proposals that we made.
Ms. Garrison.
Public reviews with meaningful truth-finding capacity. These DRCs must be given statutory powers so they have the capacity to actually truth-find, meaning they're able to be more than a rubber stamping mechanism on an internal investigation. Examples of these statutory powers are mandating an independent adjudicator, including a procedural right to cross-examine witnesses under oath, and providing the DRCs with the authority to order production of documentary evidence. These procedural safeguards ensure there is real capacity for the DRCs to truth find. Without these powers, a review committee may ultimately do more harm than good, than by lending increased credibility to what is ultimately merely an internal investigation. Further, the work of the DRCs must be made publicly available, and the procedure of the DRC itself must be included in the Act. At a minimum, we need a legislative guarantee that the recommendations will be made public. In order to act on whatever recommendations come out of the DRC, we need to have a full understanding of what they are and how to move forward with them. Without the Act mandating public disclosure of the findings and recommendations of the DRC, the province will be enabled to hide behind alleged privacy concerns in order to avoid public scrutiny. This has been the case with the family of Clayton Cromwell, who battled with the province for years to get an unredacted report regarding their son's death, despite calls from the Nova Scotia Freedom of Information Commissioner to release this information. This is not an allegation of bad faith. However, it is a demand for an act that does not enable bad faith, and one which ensures that, if bad faith occurs, it is identified and made known to the public. This is the meaning of an effective mechanism of oversight. We ask, what is the meritorious reason for not including transparency in the Act? Now moving on to mandatory reviews. Whether in the form of investigations conducted by DRCs or a judicial fatality inquiry, the review of in-custody deaths must be made mandatory. Dr. John Butt, the former medical examiner of Nova Scotia and Alberta, has argued publicly that it is a problem that our province does not require mandatory public inquiry processes in response to deaths in custody. Why are we advocating for mandatory public processes? There are 4 reasons. Firstly, where a death has occurred in custody, we have the responsibility to know whether that person was subject to abuse or neglect. Secondly, to inform changes to prevent future similar deaths, which require the assessment of institutional policies and responsibilities, as well as, which was done in the Howard Hyde inquiry. Thirdly, this change would bring us in line with most other Canadian jurisdictions, including British Columbia, Alberta, Saskatchewan, Manitoba, and Ontario, all of which require mandatory inquiries in cases where persons die while in custody. Inquiries should be mandatory and public because that is what the families of people who have died in custody want. It's what Sheila Hiles wants, Greg's mother, Greg Hiles. It's what Clayton Cromwell's family wanted. It's also what Jason LeBlanc's father, Ernie, wanted. There seem to be 3 objections to mandating public health reviews procedure beyond what we currently have under the Act: cost, delay, and effectiveness. It may be argued that judicial fatality inquiries are too costly, that they may delay more important cases on court dockets, and that the resulting recommendations would not provoke change.
2 more minutes.
Amendments can include mechanisms for cutting the process short where it is clear that a death was from natural causes and not related to institutional policies or conduct. In Alberta, if a person dies in custody, the medical examiner must be notified and the death must be investigated to determine its cause. Then, the medical examiner must inform the Alberta Fatality Review Board, which determines whether to recommend the minister convene a formal public inquiry. The board must recommend an inquiry unless satisfied that the death was due entirely to natural causes, not preventable, and that the public interest would not be served by a public fatality inquiry. Regarding effectiveness, the Act can implement measures to ensure recommendations do in fact drive change. In Alberta, they have instituted a public database with information on all recommendations coming out of judicial fatality inquiries, including the responses of those required to make changes.
So we also want to make one more point regarding the importance of public inquiry.
I'll just get your mic on there, Mr. Critchley.
Thank you. And that's to say that the court has recognized the importance of the open court principle, and this is highly relevant to the operation of the DRCs, and particularly the necessity of ensuring that the Act includes provisions requiring that the work of the committees and their findings and recommendations be made public. So as the Supreme Court of Canada acknowledged in N. Dean v. British Columbia in 2016, the open court principle embodies the importance of ensuring that justice be done openly, which is one of the hallmarks of a democratic society. The court went on to reiterate dicta from their decision in Edmonton Journal v. Alberta from 1989, noting that the open court principle is rooted in the need, 1, to maintain an effective evidentiary process, 2, to ensure a judiciary and juries that behave fairly and that are sensitive to the values espoused by the society, 3, to promote a shared sense that our courts operate with integrity and to dispense justice, and 4, provide an ongoing opportunity for the community to learn how the justice system operates and how the law being applied daily in the courts affects them.
At your 10, you're welcome to finish up.
Thank you so much. As much openness as possible helps to ensure that community voices are brought to the process, which promote a sense of civic involvement. The inquiry is not conducted in a defensive manner, reflecting a close-the-ranks mentality. Innovative suggestions for avoiding similar incidents can be fairly considered. Technical, legal, and policy dilemmas are faced openly. Fiscal cost implications for improvements are identified. Accountability by private actors and institutions is guaranteed. The input of family and advocacy groups will be welcomed and supported. Deceased persons, who will often have come from stigmatized and marginalized segments of community, will be recognized as citizens and community members to be treated with dignity, respect, and compassion, even after their deaths. And to ensure that the die is cast for other institutions in our democracy, such as the court and the legislature, to see their responsibilities in a clearer light. So, go ahead.
In conclusion,
Ms. Garson.
yes. These amendments currently before the House do not enable their stated goals. That should be a concern. However, options do exist to ensure these goals are better met. We have proposed them today, and we ask the proposed amendments not be passed in their current form. There is no need to speed through passing these amendments when the public can be better served in more thoroughly canvassing other options. Nova Scotians deserve better. Thank you.
Thank you very much. We've got about 3.5 minutes if there are any questions from the committee. Ms. Chender.
Thank you for your presentation. Thank you for appearing. We heard from the minister in response to the request to make these open that there were privacy concerns and that he was also concerned about legal liability attaching to people who might be involved in these committees. I'm wondering what you have to say to that, or what your sense of that is.
Ms. Garson.
Thank you. I wonder why there is, I guess, such select protection over people who have legal liability and who don't. Is there a question around the fairness of determination of liability? Perhaps we should address our legal liability finding mechanisms. Otherwise, if somebody should be found legally liable, regardless of their status in society, they should be found legally liable. And I know that's very uncomfortable, but that's a fact.
Ms. Adams.
Thank you. You mentioned at the very beginning that there were 12 people who had died in jail. I'm wondering how many of those deaths were investigated at the time?
Mr. Critchie.
Oh, none of those deaths have been investigated. The last judicial inquiry was the Howard Hyde inquiry. The inquiry was completed in 2010. Howard Hyde died in 2007, I believe. The deaths that we were talking about only go back as far as 2011, so it's in the period from 2011 to 2019, there were 12 deaths, and that's exclusively referring to specifically punitive detention, so it's correctional facilities. So that's not even including people like Greg Hiles, right, who've died at East Coast Forensic. It's not including anyone who died in a home governed under the Home for Special Care Act. So there are more deaths than that, right? But
Ms. Adams on a supplementary.
Thank you. Thank you for that. And how many of the families would you have been in contact with?
Ms. Garson.
Of those specific families, one, although we have been in contact with other families previous to the 2011 date who discuss quite publicly their extreme frustration at learning the death of a loved one and running into barrier after barrier to learning the causes of the death. But since the 2011 period, one.
Mr. Critchley.
I'd also like to add that our very next speaker, Darlene McEachern, is the Executive Director of the Elizabeth Fry Society of Cape Breton, has worked with the Elizabeth Fry Society for 33 years, and she's going to be speaking exactly to this point, which is supporting families when they're face every roadblock imaginable, even in terms of trying to get basic facts about how their child died.
Great. All right. Well, thank you very much. Ms. Darlene McEachern.
Thank you.
Welcome, Ms. McCracken.
Thank you.
You can proceed.
Thanks. I would like to begin by acknowledging that we are in Mi'kmaq, the ancestral and unceded territory of the Mi'kmaq people. We would like to thank the Mi'kmaq people for permitting us to gather on their land and acknowledge the importance of this conversation in light of the fact that Indigenous women are the fastest growing prison population in Canada. We've heard a comprehensive legal summary from Mr. Critchley and Ms. Garson, which clearly sets out compelling reasons for changing Chapter 31 of the Fatality Investigations Act. The Canadian Association of Elizabeth Fry Societies, the Elizabeth Fry Society of Cape Breton, and the Elizabeth Fry Society of Mainland Nova Scotia support and endorse the recommendations provided by them on behalf of East Coast Prison Justice Society. I would like to add to their submissions by discussing my experiences working with the Elizabeth Fry Society for the past 33 years. In particular, I'd like to bring a human perspective to our understanding of the imprisonment, humanness, and the importance of the learning that must take place after a death in prison. Prisons are microcosms that bring together some of our most marginalized and institutionalized people. We know that women, especially Indigenous women, are the fastest growing prison population in Canada. And to put that in perspective, in 1995, when Nova Institution for Women, which is the Atlantic Federal Prison for Women, opened, there were 13 federally sentenced women in the 4 provinces in the Atlantic. Within 2 years, we had a 500% increase in the number of women sentenced to prison, and today we have in excess of 70 women. 70 women who've been forced to live in a community that is intimate and all-encompassing. When one of the members of that community dies unexpectedly, the community is devastated, which is no different from our own community, with the exception of no public investigation, no answers, no closure. In that community of Nova Institution in the last 5 years, 3 women have died. Over my 33 years, I've witnessed the aftermath of a death in prison, and it usually begins with frantic calls to my office saying, someone has died, no one knows why, and no one has told us anything. On one occasion, my colleague Emma Halpern and I attended prison 3 days after a death, and were shocked to learn that staff were wearing masks and cleaning with a strong cleaner used for biological hazard, and the women were not told why. Can you imagine what that is like? You are grieving your community member, but are wondering what she died of, and will this affect my health? By not explaining what has happened, it's cruel and unusual punishment. On another visit after yet another death, I spoke to a woman who was in the cell across the hall from the woman who died. They saw their community member dying in front of them, saw and heard the attempts to revive the person, but never were told what the person died of, what, if anything, could have been done to save her, and what, if anything, could have been done to prevent the death. How does a community move forward when you witness such a thing? We're talking about real people who have the least ability to cope with such trauma and have the least access to information, have to utilize prison services in which all of their thoughts, feelings, and responses will be outlined in documents that will be used to determine their release. We must learn from these situations. When we remove people from our towns, our cities, and our villages, we take away their freedom. That should not entitle us to take away the rule of law afforded to other institutions. When we allow prisons and jails to investigate themselves to determine what information is provided, where is the transparency, the humanness, and the learning? On behalf of women in provincial and federal jails in Nova Scotia, we urge you to amend Chapter 31 to include 1, the establishing of a parallel death review committee for adults in custody, provide these DRCs with statutory powers to ensure they have the capacity to truth find, meaning they can be more than a rubber stamp on an internal investigation, and require that their findings may be made public. And 3, make these reviews into deaths mandatory, building accountability mechanisms into the Act. About 2 years ago, I had the opportunity to have dinner with families of 2 women who died in prison. They asked me to relay every meeting I could think of with their loved ones, what sort of questions or concerns they had, how they looked, were they scared, were they being treated well? You see, that's all they have left. Most families are too far away to visit. They talk on the phone, but it doesn't provide that details of having eyes on your family members. What that is and what an investigation does. It provides families with a view of the last months, weeks, and days in the lives of their families. I would end my presentation with a remark that will stay with me forever after that dinner. I'm her family, and it's bad enough that she may have been ill and I didn't know it, that she died and I didn't know it, but it's been 3 years and I still don't know what happened. How can that be? Thank you very much.
Thank you very much, Ms. McCracken. Questions? Ms. Martin?
Thank you so much for that presentation. It's really hard to hear the situations of these individuals. And from that, how does the community move forward or heal when there are no answers? As you mentioned with the hazmat suit, how do you move forward?
Ms. McEachern.
It's very difficult to move forward. Luckily, there are groups that go in like ours, and we were able to go in fairly quickly after the death. And we arranged with healthcare to have a meeting in the gym to explain there wasn't a communicable disease. They weren't in danger of dying. But to this day, I still don't have answers as to why that woman died, and nor do the women. They moved forward by, I know they tried to have a rock placed in the center of the compound, and that was denied. So they had to settle for a service within the institution, but it's not enough. I mean, women who are, and men, I can only speak to women because that's my experience, but once you have a trauma and you start compounding it with more trauma, you're just building these blankets of oppression on top of women who have no ability to cope, and you can't get trauma counseling in prisons because they won't do it. Trauma counseling is something that must go on for years, so you can't start something there and then leave them out in the community open and trying to heal. So there's very little that can sort of mitigate what's happening other than for people to know that they mattered. They mattered enough to have an investigation. They mattered enough that people actually looked into what happened.
Thank you. Mr. Jessom.
Thank you, Mr. Chair. Through you, Ms. McEachern, thanks for your time here this evening. Closing out your remarks, you quoted a statement indicating that it had been 3 years and the family was still unclear about the reason behind the death of a family member. I'm wondering if you can clarify whether or not that particular incident or that particular situation that you're referencing would have gone through its process and completed, or was that still something that was actively being investigated?
Ms. McEachern?
As to my knowledge, they had hired a lawyer and they were doing their own investigation, and I don't think it's resolved yet. So I think they're still going through that. And family members, they just don't get over things like that. They need closure. They need to know what happened to their loved one, and they hope that it wasn't something that was missed, or it would be like if I had a child in jail and something could have been done to prevent that death, I would have wanted to know that. I would have wanted those answers.
Ms. Gender.
Thank you for your presentation. Thank you for reminding us that we are in Mi'kma'ki, and also that Indigenous women are disproportionately affected by the issues that we are discussing. To that end, I wonder, your presentation and the previous presentation, in fact, draw on things that are not in this Act. So when these amendments were introduced, they were for death review committees for children in care and for the, intimate partner violence victims. You said, at the end, people need to know that they mattered, and we know that this is often an invisible population. Why do you think, given that this is not a new issue, this is not a new request to establish these investigations, that this was not included in the Act?
Ms. McEachern.
I can't imagine, and in fact, when we had the 3 deaths at Nova, we did a press conference, our national office, myself, and Dr. Archie Kaiser, and I don't think I realized up until that point that it wouldn't automatically trigger an investigation. It was shocking, and we were asking the government of Nova Scotia to do an inquiry, to do an investigation, and they were refusing. I don't know, it's unbelievable to me that, any unattended death by a physician why it's not covered, especially in a prison setting. I mean, where there's very little transparency, it's behind the wall of, and I'm not saying that prisons do bad things, but I'm just saying if we're going to be involved in housing people and taking them from their communities, then I think our due diligence is to the families if something were to happen to them while they're in our care.
Ms. Adams?
Thank you very much. I have two questions for you. The first is, of the 12 people who died while incarcerated, do you have a breakdown of how many, or an estimated breakdown of how many were by suicide, violence, or illness?
Ms. McCracken?
Okay.
I do not.
Ms. Adams?
Thank you. So all Nova Scotians have a right to access their medical records by simply putting a request in writing, and you may have to pay for the copies. So if someone was sick while they were in prison, are they not entitled to the same access to their medical records?
Ms. McCracken?
Not to my knowledge, not in the federal prison. I can't speak to the provincial jail. The 3 deaths I've had have been in federal prison, and the federal prison has its own healthcare system. It doesn't rely on our healthcare system, and I know that the families had a very difficult time finding out how their loved ones had died, and it had been 3 years at that point. I think they know now. But it's because of the legal inquiry that's happening. It's not because of what's happened.
One other, Ms. Adams?
Thank you for that, and I thank you for the distinction between the federal and the provincial. So do you know of anybody in a provincial prison who died from an illness that was not able to access their own medical records?
Ms. McCracken?
I do not.
Great. Thank you, Ms. McCracken. Ms. Gender?
I'd like to move an amendment.
You may make a motion, yes?
Thank you.
Oh, we do have other presenters.
Would it be better to wait until the presenters are done? Sure.
All right. Thank you. Then let's move to Michael Perry. Is he here? Okay, we're a bit ahead of time, are we? 15 minutes. Ms. Miller?
Yeah, I believe Michael Perry was speaking to the House of Assembly Act, the boundary reviews. I believe that this is an incorrect allocation on the Fatality Investigations Act.
Okay.
Yeah.
Okay, well, we are going to be jumping around between acts, so maybe we'll just move along to the next person that... no, we've got one at 9 p.m. and one at 9:30. So let's see if we move now to Bill 187, the House of Assembly Act. Is Norbert LeBlanc ici? Oh, sorry, it's Norbert and Marie-Claude Rio. Bienvenue. Bonsoir. Vous pouvez commencer.
Merci, Monsieur le Président du Comité de modification des lois. Je m'appelle Norbert Leblanc. Je suis président de la Fédération acadienne de la Nouvelle-Écosse. Notre fédération est une fédération active qui accomplit sa mission en agissant comme porte-parole principale de la population acadienne, en facilitant la concertation et le partenariat de l'ensemble des organismes œuvrant au sein de la communauté acadienne, en offrant des services et des programmes répondant aux besoins de ses membres et en appuyant ses membres dans ce développement. Depuis ses débuts, en 1968, La Fédération acadienne de la Nouvelle-Écosse a contribué à la naissance et à l'avancement de plusieurs dossiers pour la communauté acadienne, notamment dans les domaines de l'éducation, de l'économie, de la politique, de la justice, de la santé, de la culture, de la jeunesse, des femmes, des aînés, de l'alphabétisation et de l'immigration. Par sa présence aujourd'hui, la Fédération acadienne représente aujourd'hui l'ensemble de la communauté acadienne de notre province, ainsi que ses 28 organismes régionaux, sectoriels et institutionnels. Maintenant, c'est mon plaisir de demander à Mme Rioux, qui est la directrice générale, de présenter les grandes lignes de mémoire que nous vous présentons ce soir.
Merci, Monsieur Leblanc. Madame Rio.
Monsieur le Président, bonsoir. Bien que la Fédération acadienne juge de façon positive le rapport final de la Commission de délimitation des frontières électorales, en particulier la recommandation de rétablir les anciennes circonscriptions électorales acadiennes exceptionnelles de Clare, d'Argyle et de Richmond, elle est extrêmement déçue de la décision partagée à 5 contre 4 de ne pas recommander de circonscription ou de députés acadiens pour la région de Chéticamp. Vous savez, la Fédération acadienne demande une circonscription pour Chéticamp depuis 1992. Elle l'a demandé en 92 lors du premier la première commission de délimitation. Elle l'a demandé en 2002. Elle l'a redemandé en 2012 et elle l'a redemandé encore cette année. La Fédération acadienne reconnaît l'indépendance de la Commission de délimitation des frontières électorales, mais estime que le rapport de cette dernière présente d'importantes iniquités et lacunes, en particulier quant à l'analyse constitutionnelle relative à la création d'une circonscription exceptionnelle pour Chéticamp. En effet, la Fédération acadienne estime que la Commission de délimitation des frontières électorales a négligé d'appliquer les principes de représentation effective présentés dans le renvoi relatif aux circonscriptions électorales provinciales, aussi nommé l'arrêt Carter, et dans le mandat de la Commission figurant dans le House of Assembly Act pour effectuer son étude d'une circonscription exceptionnelle pour Chéticamp. Par ailleurs, le mandat de la Commission de délimitation des frontières électorales, tel que défini dans le House of Assembly Act, reprend les mêmes facteurs géographiques, historiques, culturels ou linguistiques pour justifier la création de circonscriptions exceptionnelles, notamment aux sous-paragraphes B et C du mandat. Toutefois, dans son rapport final, la Commission ne fournit aucune raison pour justifier le rejet de l'option d'une circonscription pour Chéticamp ou d'une double députation pour Inverness, mis à part le nombre d'électeurs ou la parité électorale. Autrement dit, la lentille de la représentation effective ne semble pas avoir été appliquée pour la circonscription de Chéticamp, alors qu'elle l'a été pour les autres circonscriptions exceptionnelles créées par la Commission. La Fédération acadienne juge que la région de Chéticamp a été doublement marginalisée. Triplement, peut-être. En fait, très largement marginalisée, même par rapport aux autres circonscriptions acadiennes. Vous savez, la dernière fois que les Acadiens de la région de Chéticamp ont pu élire un Acadien, c'était en 1926. En 1932, une partie des Acadiens de la région de Chéticamp ont été expropriés pour créer le parc des Hautes-Terres du Cap-Breton. Il n'y avait pas d'Acadiens députés pour défendre leurs intérêts à l'Assemblée législative à ce moment-là. Il n'y en avait pas non plus en 92, en 2002 et en 2012 lorsqu'on a demandé à répétition d'avoir une circonscription pour Chéticamp. Alors la Fédération juge qu'en insistant sur la parité des électeurs, Sans tenir compte de la représentation effective des Acadiens de Chéticamp, la Commission de délimitation des frontières électorales perpétue les torts causés à cette communauté. Nier le droit à une représentation effective à la communauté acadienne de Chéticamp, sous prétexte que cette communauté est trop petite, alors que ce droit est protégé dans d'autres communautés de dimensions similaires, je pense notamment à Guysborough, Eastern Shore, Tracadie, alors que la région de Chéticamp remplit, selon nous, l'ensemble des critères pour une représentation effective, c'est faire abstraction des facteurs géographiques, historiques, linguistiques et culturels qui caractérisent cette région. C'est empêcher la communauté de se maintenir en tant qu'entité linguistique et culturelle distincte et c'est contribuer à son assimilation. Je vais donner la parole au président qui va conclure en formulant les recommandations que nous vous soumettons.
Monsieur LeBlanc.
Monsieur le Président, si vous me permettez, nous avons 3 recommandations que nous proposons à ce comité de modification de loi. La première, la Fédération acadienne de la Nouvelle-Écosse estime que le présent comité de modification aux lois a le devoir de corriger les iniquités et les lacunes du rapport final de la Commission de délimitation des frontières électorales, en particulier pour ce qui est de l'analyse constitutionnelle relative à la création d'une circonscription exceptionnelle pour Chéticamp. Nous demandons au comité de modification aux lois de déroger au rapport final de la Commission de délimitation des frontières électorales en créant une circonscription électorale exceptionnelle pour la région de Chéticamp. Les limites de cette circonscription pourraient s'établir comme suit. On peut voir les limites proposées qui sont à la page 9 de notre mémoire. Notre troisième recommandation, la Fédération acadienne invite le comité de modification aux lois à donner ce statut protégé à l'ensemble des circonscriptions acadiennes puisqu'il a été clairement établi dans le rapport de la Commission sur la représentation effective que la communauté acadienne a été marginalisée au même titre que la population afro-néo-écossaise. En terminant, Monsieur le Président, vous trouverez dans vos trousses un avis juridique préparé par Maître Michel Doucette. On vous demande, avant de prendre une décision, de regarder, de lire cet avis juridique. Et nous recommandons, en lisant cet avis juridique, vous pourrez voir que l'avis nous appuie dans nos arguments pour accorder une circonscription protégée à Chéticamp. Je termine mes commentaires.
Merci beaucoup. Avez-vous des questions? Pas de questions? Merci beaucoup. Mademoiselle Evelyn LeBlanc-Joyce. Bonsoir, Madame LeBlanc-Joyce.
Bonsoir, merci. Alors, je m'appelle Evelyn LeBlanc-Joyce et je représente la Société acadienne de Clare ce soir. Alors, la Société acadienne de Clare est l'association membre de la Fédération acadienne de la Nouvelle-Écosse pour la région de Clare. Et à ce titre, elle regroupe les personnes, organisations et associations vouées à l'épanouissement des Acadiens et Acadiennes de la baie Sainte-Marie et qui sont engagés à valoir la richesse de la langue et de la culture acadienne de la baie Sainte-Marie. Pour accomplir ceci, la Société acadienne de Clare favorise la concertation, les partenariats et les alliances stratégiques en initiant des projets et activités communautaires en collaboration avec ses membres et partenaires, en exerçant un leadership visant l'offre active et l'utilisation des services et programmes en français, en renforçant les capacités de ses membres, en agissant comme porte-parole de la communauté acadienne de la baie Sainte-Marie et en informant et en sensibilisant la population à la vie acadienne de la baie Sainte-Marie. La Société acadienne de Clare se réjouit de la recommandation de la Commission de d'élimination des frontières électorales, en particulier de sa recommandation de réétablir l'ancienne circonscription électorale acadienne exceptionnelle de Clare. Toutefois, la Société acadienne de Clare est déçue de constater que le désir de la communauté de Chitican et des environs d'avoir une circonscription exceptionnelle n'a pas été accordé, et ce, en dépit des demandes réitérées depuis 1992. Tout comme la Fédération acadienne, la Société acadienne de Clare est d'avis que les régions de Richmond, de Clare, d'Argyle et de Chitican sont toujours considérées par l'ensemble de la communauté acadienne comme étant les 4 régions traditionnelles acadiennes d'importance. Le fait de ne pas tenir compte de cette réalité et de ne pas accorder une circonscription électorale exceptionnelle pour la région de Chitican contribue davantage à la marginalisation de cette région. Par conséquent, et en solidarité avec la communauté acadienne de Chitican, la Société acadienne de Clare appuie la Fédération acadienne dans sa revendication de circonscription exceptionnelle pour Richmond, Clare, Argyle et pour Chitican. La Société acadienne de Clare appuie également la demande de la Fédération acadienne pour que ces circonscriptions acadiennes soient dorénavant protégées. Nous vous remercions de votre attention et de votre temps ce soir. Merci.
Merci beaucoup. Est-ce qu'il y a des questions? Non? Merci beaucoup. Let's go through this. Alors, le prochain, c'est Lisette Aucun-Bourgeois. Bienvenue.
Merci.
Madame Aucun-Bourgeois. Mon français, ce n'est pas très bien, excusez-moi.
Ça va. Bonsoir, mon nom est Lisette Aucoin-Bourgeois, directrice générale de la Société Saint-Pierre. Notre société, fondée en 1947, est pour les Acadiens de la grande région de Chitican, l'organisme qui veille à préserver et à promouvoir la langue et la culture acadienne. La Société travaille incessamment au développement communautaire, touristique, économique des Acadiens de la région. Nous sommes fiers propriétaires du Centre culturel Les Trois Pignons et par le biais de notre musée, galerie, du tapis hooké et davantage par notre centre de généalogie, se veut la protectrice de notre histoire et de nos ancêtres. Porte-parole par excellence de tous les Acadiens de la région de Chitican, Saint-Joseph-du-Moine et Magré, la Société Saint-Pierre n'a jamais manqué d'assumer sa responsabilité dans la revendication de nos droits en tant que minorité linguistique et culturelle. En 1991, lors de la Commission sur la révision de la carte électorale en Nouvelle-Écosse, la communauté acadienne de Chitican avait présenté un mémoire. Pour des raisons qui ne seront jamais claires, notre région avait été complètement oubliée et négligée dans la mise en place des circonscriptions acadiennes. Une reconnaissance comme en avait été le cas pour Richmond, Clare et Argyle. Qu'en fut les raisons, le résultat a été que la région de Chitican n'a pas bénéficié d'une représentation équitable, au même titre que les autres régions acadiennes ayant bénéficié de circonscriptions protégées. Nous avons de nouveau présenté lors de la Commission sur la représentation effective, la Commission KIF, en 2017, pour mettre à point notre déception et nos préoccupations. En septembre 2018, nous avions l'occasion de présenter devant la Commission de révision des frontières électorales et partager nos points de vue sur la représentation effective pour notre communauté acadienne de Chéticamp. Notre message était clair, ne pas cette fois-ci négliger la région acadienne de Chéticamp dans les discussions et décisions prises. En janvier 2019, avec salle comble, nous avons de nouveau présenté devant la Commission de délimitation des circonscriptions électorales. La Société Saint-Pierre suppliait de ne pas nous ignorer dans son rapport final et de nous accorder notre propre circonscription. Quand le rapport du mois d'avril 2019, avec la décision de 5 contre 4 de ne pas recommander de circonscription ou de députés acadiens pour la région de Chéticamp, nous étions tous énormément déçus. Dans le rapport final de la Commission de délimitation des circonscriptions électorales, une lettre d'opposition signée par les 4 membres qui auraient voulu une circonscription extraordinaire en conclut en disant « En ce qui concerne Chéticamp et ses environs, cependant, nous pensons que nous n'avons pas bien fait les choses. Que réserve l'avenir? Les Acadiens de Chéticamp et des villages environnants bénéficieront-ils à l'avenir d'une représentation plus effective? Si c'est le cas, comment? Pour le moment, nous pensons que les Acadiens de Chéticamp et les villages environnants se voient, une fois de plus, figés dans une représentation insuffisante. Alors, nous voici devant vous, 6 mois plus tard, aussi tenaces que jamais et encore avec espoir que vous jugerez bon de créer une circonscription extraordinaire pour la région de Chéticamp avant l'adoption de la loi numéro 187. Nous avons cru valable de faire ce voyage de 10 heures aller-retour pour venir renforcer notre message et aussi pour appuyer le mémoire présenté par la Fédération acadienne de la Nouvelle-Écosse et de Maître Régent Aucoin, qui va venir. Nous endossons ces 2 mémoires. Nous ne lâcherons jamais notre lutte de nous doter d'une communauté acadienne qui aura enfin tous les outils nécessaires pour lui redonner confiance, un sentiment d'appartenance et une dignité qui lui permettront de contribuer de façon dynamique, collaborative et inclusive au développement de la Nouvelle-Écosse. Une communauté qui aura les outils lui permettra de s'épanouir et de se sentir partie intégrante de la société à laquelle elle appartient afin d'assurer la sauvegarde de la langue française pour les générations à venir. Merci pour votre attention.
Merci. Merci beaucoup. Est-ce qu'il y a des questions? Non, merci. Merci pour votre présentation. Prochain est Josette Marchand. Vous avez des copies là? Oui. If we could ask the page to get those circulated. Bienvenue. Proceed.
Merci. Bonsoir. Permettez-moi de vous remercier, le comité législatif, d'avoir réservé du temps pour entendre notre position concernant ce projet de loi. L'APICAS, Centre communautaire culturel, est l'association membre de la Fédération acadienne de la Nouvelle-Écosse pour la région de Richmond et, à ce titre, œuvre à la promotion de l'épanouissement de la langue française et de la vitalité de la culture acadienne. L'APICAS poursuit les buts suivants. Par le biais de l'éducation, supporter l'avancement de la langue française, instruire et renseigner les Canadiens et Canadiennes sur la culture acadienne et francophone par l'organisation d'événements communautaires, artistiques et culturels, par des programmes d'éducation ainsi que par la collecte et la classification de données portant sur l'histoire de la communauté, fournir des installations pour mener à bien des activités et d'encourager la recherche, la publication et la diffusion d'informations attachées à l'éducation du patrimoine acadien. La PICAS est entièrement satisfaite de la décision du gouvernement provincial de déposer ce projet de loi visant à rétablir la circonscription électorale acadienne exceptionnelle de Richmond, de Clare et d'Argyll. Nous partageons la déclaration de la Fédération acadienne de la Nouvelle-Écosse que les régions de Richmond, de Clare, d'Argyll et de Chéticamp sont toujours considérées par l'ensemble de la communauté acadienne comme étant des régions traditionnelles acadiennes. La PICAS est déçue de la demande de la communauté de Chéticamp d'avoir une circonscription exceptionnelle n'ait pas été recommandée par le comité de révision des frontières électorales. Par conséquent, et en solidarité avec la communauté acadienne de Chéticamp, la PICAS appuie Chéticamp dans sa revendication de circonscription exceptionnelle pour cette région. La PICAS appuie également la demande de la Fédération acadienne de la Nouvelle-Écosse pour que ces circonscriptions acadiennes soient dorénavant protégées. Merci de votre attention.
Merci, Madame Marchand. Est-ce qu'il y a des questions? Alors, merci beaucoup. Le prochain, c'est Luc Dion. Bienvenue, Monsieur Dion.
Merci. Je m'appelle Luc Dion et je représente le Conseil acadien de Parent-Bas. Le Conseil acadien de Parent-Bas est l'association membre de la Fédération acadienne de la Nouvelle-Écosse pour la région d'Argyll et à ce titre œuvre à la promotion et à l'épanouissement du développement global de la communauté acadienne et francophone de la région d'Argyll. Le Conseil acadien de Parent-Bas poursuit les buts suivants. Être le porte-parole principal de la population acadienne et francophone de la région d'Argyll, faciliter la concertation et le partenariat de l'ensemble des associations œuvrant au sein de la communauté acadienne et francophone de la région d'Argyll, tout en respectant le mandat de chaque association, offrir des services et des programmes répondant aux besoins de ses membres, appuyer ses membres dans le développement et l'épanouissement de la communauté acadienne et francophone de la région d'Argyll. Le Conseil acadien de Parent-Bas se réjouit de la recommandation de la Commission de délimitation des frontières électorales, en particulier sa recommandation de rétablir l'ancienne circonscription électorale acadienne exceptionnelle d'Argyll. Toutefois, le Conseil acadien de Parent-Bas est déçu de constater que le désir de la communauté de Chéticamp et des environs d'avoir une circonscription exceptionnelle n'a pas été accordé, et ce, en dépit des demandes réitérées depuis 1992. Tout comme la Fédération acadienne, le Conseil acadien de Parent-Bas est d'avis que les régions de Richmond, de Clare, d'Argyll et de Chéticamp sont toujours considérées par l'ensemble de la communauté acadienne comme étant les 4 régions traditionnelles acadiennes d'importance. Le fait de ne pas tenir compte de cette réalité et de ne pas accorder une circonscription exceptionnelle pour la région de Chéticamp contribue davantage à la marginalisation de cette région. Par conséquent, et en solidarité avec la communauté acadienne de Chéticamp, le Conseil acadien de Parent-Bas appuie la Fédération acadienne dans sa revendication de circonscription exceptionnelle pour Richmond, Clare, Argyll et pour Chéticamp. Le Conseil acadien de Parent-Bas appuie également la demande de la Fédération acadienne pour que ces circonscriptions acadiennes soient dorénavant protégées. Nous vous remercions de votre attention.
Merci beaucoup. Est-ce qu'il y a des questions? Non, merci. Merci, Monsieur Dion. Okay, I think now, I think Michael Perry has arrived, and so we will, Mr. Perry, are you here? And Mr. Perry, there's a bit of confusion. Are you here to speak to Bill number 180, or? The Electoral District Congress. 187, then. Welcome, please. So just a reminder that we have 15 minutes per presenter, 10 minutes for presentations, 5 for questions, but you can adjust that at your wish. So please begin.
Thank you very much. Sorry I was delayed getting here today. I'm here speaking on behalf of Municipality of East Hants and the residents of Mount Uniacke, to who I represent. There was a letter written from the municipality to the Premier and all the leaders of the political parties, and I'm going to read that here for you today as what was sent in. This letter is written to you today on behalf of the East Hants Municipal Council to ask that you do not approve or support the Electoral Boundary Commission report without amendment to stop the splitting up of the community of Mount Uniacke into 3 separate districts. The following items highlight the first 3 terms of reference provided to the Commission and how the Commission report does not align to what it was mandated to complete with regard to the splitting up of the community of Mount Uniacke into 3 separate electoral ridings. The first terms of reference refer to there is a right to effective representation. Electoral parity is the prime factor in determining these electoral boundaries. This was not achieved for the residents of Mount Uniacke, as the community was split into 3 separate electoral areas. This in effect does the opposite of the terms of reference, but denying these residents any form of effective representation and does not allow for an electoral parity with other communities in Nova Scotia. The second point was the deviation from electoral parity is justified because of geography. Keeping a community as a whole unit would be a reason to deviate from electoral parity, and it would be justified under this terms of reference. This falls under the reason that it is justified to keep Mount Uniacke together. The third point, the third terms of reference, deviation from electoral parity may be justified because of historical, cultural, linguistic settlement patterns and because of political boundaries. There is no more history than the fact that this area is now divided, was once home to the 1978 MLA for Hantseast, G. Patrick Hunt. This, along with the history of Richard John Uniacke, to whom the community is named after, who served in the House Assembly for over 20 years and was one of the most influential figures in early Nova Scotia. This history should be preserved and not let a community bearing his name with a history of having candidates and an MLA sit in the House of Assembly be torn apart. Beyond the terms of reference, the procedures and how the Commission was conducted did not allow a fair and equitable process for community engagement in the following ways. The idea of separation of Mount Uniacke came from a private citizen who was not at the time and is still not a member of the Mount Uniacke community. One should never pit community against community for public gain. The first public information session the Commission was considering separating Mount Uniacke from Hantseast District was only presented at the final public engagement meeting in Milford, and it provided no opportunity for the impacted community to be aware of what was happening, nor did it allow the community to invite the Commission to come to Mount Uniacke to hear from its residents, like all the other communities that were under consideration were allowed to have happen. Milford and Shubenacadie were given the opportunity to speak, and as a result, they were removed from the equation of being divided. Why was Mount Uniacke not given the same opportunity? The Commission stated that fair representation was its core of its mandate. Yet I ask, how is splitting one community into 3 fair in any way? The sitting MLA even stated that if Mount Uniacke was removed from Hantseast, that it be allowed to stay together, be named in the riding. This was not done, as the opposite was actually invoked in this report. So in closing, we, the Municipality of East Hants, ask that there is a bipartisan agreement that the Commission report should not be accepted as presented without the amendment to keep Mount Uniacke together as one community and not divided into multiple electoral districts. The positioning of which district Mount Uniacke falls into is not as important as to keeping the community as one. Thank you for your time.
Any members? Ms. Lonescroft.
Yes, could you tell me the population of Mount Uniacke?
It's hovering around 30, I think we're closing in on close to 4,500.
Any other questions? Thank you, Mr. Perry.
Thank you.
Ms. Martin.
because of the importance of this issue, and I see some written submissions, I would urge that we take a short recess and review these written submissions. I don't know how we can conclude the evening without knowing what's in these submissions, and I know for one, I have constituents in my area who weren't able to make it, so would like their voice read and heard before any decisions are made.
Okay. Ms. Miller.
Yeah, thank you. Thank you, Mr. Chair. I believe that any changes or any suggested changes or amendments can also be done through committee of the whole House. So that may not, I think we still have time to be able to look at all this information and draw conclusions before it hits the floor of the legislature and the committee of the whole House, in which opposition members will have that opportunity then to bring forward any amendments, and the government may well bring forward amendments as well.
Any other comments? We are a bit of, how many documents do we have? How many documents are you referring to? 3. We're a bit ahead of schedule, so I'm comfortable, if the committee is comfortable, to take a 10-minute break. It allows folks to use the washroom and review the documents. So we'll adjourn for 10 minutes. Thank you. Okay, order please. I'd like to get us back started here again. We've got 1, 2, 3, 4, 5 more folks to hear from. I'm not sure if they're all here or not. We'll do our best to get to everyone and at least wait them out to their appointment hour because we are a bit ahead of schedule. So next on our list is Robert Pinio. Is Robert Pinio here? He was to be here for 8:30, so we are ahead. Okay, then is Monsieur Régent Aucan here? Très bien. Bienvenue, Monsieur Aucan. Aucoin.
Aucoin, merci.
Aucoin. Vous pouvez commencer.
Merci, Monsieur le Président. Avant de commencer, je dois dire aux membres du comité que je suis avocat. J'étais un des avocats au dossier des circonscriptions électorales, le renvoi, mais je suis ici en mon nom personnel en tant que citoyen de Chéticamp. Merci, chers membres de la Commission. Permettez-moi en premier de vous dire le contexte pourquoi je suis ici. Je suis originaire de Chéticamp où j'ai grandi et travaillé. J'ai fait mes études là et à 21 ans, j'ai fait un premier bac et à 37 ans, j'ai terminé mon bac en droit. Après environ une douzaine d'années passées à l'extérieur et aux études et y travailler, je suis revenu à Chéticamp en 1993 pour travailler et j'y suis en pratique depuis. Ayant été obligé de suivre mes cours en anglais lors de mon secondaire, car à l'époque, nous n'avions pas d'école acadienne, je me suis très tôt impliqué dans l'obtention d'écoles. Mes 2 filles ont obtenu leur éducation en français à l'école de Chéticamp, mais on a quand même construit 33 écoles anglaises durant le temps qu'ils ont fait leurs études avant que l'école de Chéticamp soit rénovée. L'école acadienne qui appartient maintenant au CSAP. Je suis devant vous pour vous enjoindre de réparer une erreur historique qui date de 1992, mais qui prend racine bien avant. Malgré les mémoires présentées par la communauté de Chéticamp en 1992, la Commission sur les délimitations des frontières électorales de l'époque n'avait pas cru bon de désigner Chéticamp comme Clare, Argyll et Richmond. Le rapport de la Commission de 1992 ne toucha que brièvement la question de Chéticamp. Pourtant, le mandat de la Commission et la Commission de 2018-2019, le mandat est très clair. Selon la House of Assembly Act, il faut tenir compte de facteurs géographiques, historiques, culturels et linguistiques, ce qui peut permettre la création de circonscriptions exceptionnelles afin de justifier une déviation des parités des voix. Ceci fut par ailleurs les principes soulevés dans l'arrêt Carter, Saskatchewan contre Carter, de la Cour suprême du Canada de 1991. Les commentaires retrouvés à la page 42 du rapport préliminaire de la Commission de 2019 intitulé « Trouver un équilibre entre représentation effective et parité électorale » traitait pourtant des facteurs qui justifiaient et qui justifient toujours la création d'une circonscription exceptionnelle pour Chéticamp. Je les passe en revue au paragraphe 10. Nous proposons d'ajouter Chéticamp à titre de circonscription électorale exceptionnelle supplémentaire pour plusieurs raisons. À l'Assemblée législative, Chéticamp a été représenté par un Acadien seulement à 2 reprises depuis la Confédération. Chéticamp ne faisait pas partie des circonscriptions électorales exceptionnelles, lequel avait été constitué pendant 20 ans une reconnaissance symbolique et permis une représentation des Acadiens dans les circonscriptions protégées. Les Acadiens en particulier, et à Chéticamp et les environs, ont été marginalisés. Déportation, périphétie et au cours des siècles derniers, expropriation foncière par le gouvernement fédéral pour la création d'un parc national. Assimilation et menace de survie. La création d'une circonscription électorale exceptionnelle permettrait donc une représentation effective pour Chitican et les environs. Ceci pourrait également permettre de définir de façon inopinée, quoique peut-être être avantageuse, des limites adaptées à la communauté culturelle et même gaélique d'Inverness. Toutefois, dans son rapport final, la Commission a choisi de ne pas créer une circonscription pour Chitican. Et là, je saute quelques paragraphes de mon rapport parce que j'ai juste 10 minutes. La Cour, comme j'ai dit, de l'affaire Carter, dit que dans ses travaux, une commission peut tenir compte de la Charte des droits et libertés, mais aussi des principes et des facteurs afin d'éviter que le vote d'un groupe devienne non équitable. Pour la minorité acadienne de Chitican, l'Assemblée législative de la Nouvelle-Écosse se doit, dans l'adoption de son projet de loi 187 sur la circonscription électorale, tenir compte de tous les facteurs énumérés dans l'arrêt Carter et dans le rapport, dans le mandat de la Commission même. Et ça comprend aussi le contexte particulier. Et par contexte particulier, je veux également dire notre situation géographique au bout de l'île du Cap-Breton et notre situation géographique par rapport aux autres régions acadiennes qui sont quand même éloignées. Une circonscription exceptionnelle serait la mesure appropriée pour peut-être nous donner une représentation effective à l'Assemblée législative. D'ailleurs, la Commission n'a pas élaboré pourquoi est-ce qu'elle avait pas, par exemple, touché à la possibilité de créer une circonscription comme celle de Argyll. Elle n'en a pas parlé. Argyll, il y a 6 451 électeurs. Pourquoi est-ce qu'on n'a pas choisi de créer une circonscription comme celle-là pour la région de Chitican? Une des réponses peut-être a été donnée par un commissaire, ça aurait trop dérangé ou ça aurait trop... Il y aurait eu beaucoup trop d'accommodements à faire à toutes les autres circonscriptions entourant cette circonscription-là. Mais c'est pas comme ça que les principes... C'est pas comme ça que la Commission devait faire son travail selon l'arrêt Carter. D'autre part, 4 des 9 commissaires, dans leur lettre de dissension, semblent avoir compris clairement ce point. Puis ils disent, et je vais le dire en anglais, "It has been argued that the Commission's proposal to address effective representation in Chitican and environ yielded an unacceptable deviation from voter parity. We respectfully disagree. Chitican and its surrounding communities present an extraordinary case of a linguistic, cultural, historical, and geographical community of interest needing more effective representation at a crucial time. We refer to Justice McLaughlin's statement about voter parity and effective representation in the Carter decision." At paragraph 49, "It is my conclusion that the purpose of the right to vote enshrined in Section 3 of the Charter is not equality of voting power per se, but the right to effective representation. But parity of voting power through the prime importance is not the only factor to be taken into account in ensuring effective representation, notwithstanding the fact that the value of a citizen's vote should not be unduly diluted. It is a practical fact that effective representation cannot be achieved without taking into account countervailing factors." That was the Saskatchewan decision, or Carter. Un représentant acadien pour notre région parlant notre langue pourrait nous permettre, enfin, de regagner ce que nous avons perdu et de défendre nos intérêts auprès de la province. Ceci serait indéniablement un atout pour notre avenir. Ce n'est pas par hasard qu'aujourd'hui la population acadienne de Chitican est en décroissance. Il nous manque un leader, un porte-parole, une personne pour défendre nos intérêts aux plus hautes sphères de la province. Et je donne quelques exemples. La fermeture du bureau d'enregistrement des véhicules à moteur à Chitican, la centralisation de services de santé et le bloc opératoire à Inverness. Du côté juridique, les gens de Chitican, Pleasant Bay et Nico doivent se rendre à Port Hawkesbury pour aller en cours pour toutes les affaires civiles, familiales et criminelles. On a fermé la cour à Chitican en 90. Une demande de créer une cour satellite comme à Ingonish, où elle existe depuis 20 ans, n'a toujours pas eu écho à la province. Et on n'a toujours pas de cour à Chéticamp. Et que dire du foyer Père Fizette, qu'on a agrandi de quelques lits alors que celui d'Inverness a été reconstruit à neuf, alors que les deux foyers avaient été construits la même année. Et nos noms de lieux très importants pour nous, Acadiens, dans notre âme. Par exemple, le Belle Marche a été changé à Chéticamp Back Road avec l'instauration du 911. On a Prairie Spur Road au lieu de la Prairie, Mountain Road au lieu de Le Fort Road, pour n'en nommer que quelques-uns. Avoir un siège plus ou moins à l'Assemblée législative et des coûts avoir un siège de plus à l'Assemblée législative et les coûts supplémentaires que cela entraîne sont des facteurs importants, mais pas nécessairement des facteurs déterminants quand on parle du droit de la minorité d'avoir une représentation effective.
Ça va être 10 minutes, mais tu peux continuer si tu veux.
J'ai presque fini, merci.
Oui.
Aujourd'hui, les Acadiens de Chéticamp savent bien qu'il est quasi impossible et même illusoire d'avoir l'un des leurs d'être élu à l'Assemblée législative, car même si tous les Acadiens de la circonscription votaient pour le même candidat, la majorité écossaise et anglaise qui voterait contre le vote des Acadiens ferait en sorte que leurs représentants ne seraient pas élus. Et n'oublions pas la loi sur le service en français, dans son préambule, qui dit que la collectivité acadienne et francophone de la Nouvelle-Écosse a beaucoup fait pour la Nouvelle-Écosse, que la Nouvelle-Écosse entend bien promouvoir le développement de sa collectivité acadienne et francophone et tient à la sauvegarde des générations à venir. En d'autres mots, la province, l'Assemblée législative n'a-t-il pas un devoir de fiduciaire envers les Acadiens? Comment peut-elle aujourd'hui nous nier une représentation effective à l'Assemblée législative tout en conciliant avec la loi sur les services en français de la Nouvelle-Écosse? Alors, je vous demande, je fais du mien le rapport de la Fédération acadienne, je vous demande de créer une 56e circonscription pour la région de Chéticamp. Finally, in the grand scheme of things, would the cost of a fixed 56 electoral boundary make that much difference? The 2000 Commission has done an excellent job, but generally, but has missed an important link. The previous government of this province is known by all Acadians in the province, about 35,000, as the government who decided that the Acadians in Nova Scotia did not merit to have a protected riding or to be recognized or to obtain the recognition that they should. Would this government want to be the government to be known by all Acadians of this province as the government who decided that Chéticamp did not merit its own riding? Thank you. I'm open to questions in English or French.
Merci beaucoup, Monsieur Aucan. Ms. Martin.
Thank you so much for your presentation, and my apologies, my French is terrible. So I spent many years in Chéticamp, and still do. My parents had a place on Chéticamp Island for about 25 years that we enjoyed every summer, and I appreciate the culture and the community. So I have two questions. First of all, and I will not even try to pronounce the names, but where would you see the riding starting and finishing? Like, so I'm picturing when I'm driving in, what would be the starting point and what would be the ending point in your opinion?
Monsieur Aucan?
Well, if we refer to the 56 riding that was suggested in the preliminary report, and it's not the community that suggested it, it was the commission, then the riding would go from Meat Cove to Doyle Bridge near the Margaret Forks Co-op. That would be like the traditional Acadian area up to Doyle Bridge, and Meat Cove and Pleasant Bay have always been, with one exception, in our riding, and they do their business in Chéticamp.
Madame Martin?
Thank you. So that would include Grand Tang and Belcote and those different areas. And then my other question is, what is the total population of that area?
Monsieur Aucun.
It would, I can't tell you. It's about 5,000. The number of electors would be about 2,500.
Merci. D'autres questions? Alors, merci beaucoup. Did Robert Pinio arrive? Yes. Great. So we'll move back to Bill number 169, the Expropriations Act. Welcome, Mr. Pinio. Our format here is total 15 minutes, 10 for presentation, 5 for questions, but you may choose to speak for whatever amount you so wish, but we try to wrap it up within 15. So the floor is yours, Mr. Pinio.
Thank you. This is my first time before the Law Amendments Committee, so if I'm a little off on procedure, please forgive me. I'm here as a lawyer who regularly represents landowners and expropriating authorities in compensation claims. I represent 3 municipal units on the expropriating authority side, and I represent many multiple dozens of landowners who've had their lands expropriated or injuriously affected. And because there are so few expropriated landowners available at any given time in Nova Scotia, there's not the ability for that group to come together and lobby the government or to speak to law amendments. So I'm here tonight without instructions from clients on either side of the fence, but to make submissions that I feel are important in relation to Bill 169. And as I've always been taught to do, you speak to the good and the bad. In my opinion, Bill 169 has some positive attributes to it. Certainly modernizing the language of the Act is important. I don't take issue with the clarification that for disturbance damages, the landowner must actually be in possession of the land as opposed to a more speculative use of land that they own. I commend the legislature for putting that part of the bill through. It brings clarity to the practice of law on both sides of the spectrum. The difficulty that I have goes back more to the very basis of expropriation compensation law. And without getting into a long diatribe about the history of expropriation law, at one time the Crown could take land or any possessions from a subject and not have to pay any compensation. And that's evolved, over 800 or 900 years to get to the early 1970s when 6 provinces in Canada come under what is known as the reform legislation, Nova Scotia being one. And that legislation revolutionized landowners' rights. That is, that landowners could not have their rights, their land taken away without a presumption of fully compensating the landowner. So to bring this into the specter of Bill 169, I see that the legislature or the sponsoring members are seeking to take away landowners' rights to seek compensation for injurious affection where there has been no taking. And I'm not sure why where the reasoning comes from that the compensation will be heard by the Supreme Court as opposed to the Nova Scotia Utility and Review Board. The Utility and Review Board is a ministerial appointed board independent of the government who has developed a specialty over the last 40 years between the current board and the previous Expropriation Compensation Board in dealing with these types of issues. So now to take those claims away from the specialized tribunal that hears these cases regularly and has developed an ability that is respected by the Nova Scotia Court of Appeal to determine these issues, I think is misguided. And I would urge those provisions of Bill 169 to be pulled back and left with the Nova Scotia Utility and Review Board. I've practiced expropriation compensation law in Alberta and in New Brunswick and in Nova Scotia. And in Alberta and New Brunswick, the cases are heard, well, in Alberta they can be heard before their Supreme Court, the Court of Queen's Bench. And in New Brunswick they must be heard in the Supreme Court. And our experience there, and I'm one of the text writers for the compensation text for all of Canada, along with Stephen Waquet and others. And our collective discussions on that issue is that both the expropriating authority and the landowner receive, I have to be careful how I don't want to step on any toes, but that the issues receive a more experienced and specialized trier of fact before a specialized tribunal than they do before the general court, where a judge might only hear one expropriation case in his or her entire career. Whereas before the Utility and Review Board, each member might have heard, in the 50s or even as many as 100 cases, so that there develops a body of jurisprudence that can be relied upon by all of the members and by the public and by the expropriating authorities. That's the one issue, number one issue I wanted to raise this evening. The second would require an addition to the amendments, and I'm not sure that that's the appropriate form. When I spoke earlier that it's my first time here, I'm not sure if it's the appropriate form, but I understand on June 1st of this year, the minister in charge set up a regulation that brings costs for expropriation matters under Tariff A or Tariff C of the Nova Scotia Civil Procedure Rules. And there's two difficulties with this. And the first one is that in regular litigation in the Supreme Court, generally costs awards are made to the successful party, but they represent somewhere, and I'm speaking out of experience, between 15% of that litigant's actual legal costs and up to 30 or 40%, occasionally hitting 50%. That's especially atrocious to an expropriated landowner who's going to have their land taken away, and then in order to hire legal counsel to bring a compensation claim, have to donate part of the property that they had taken from them over to their lawyers. Up to this point in time, the scheme has worked thus. An expropriated landowner can hire counsel of his or her choosing. The bill runs. Then at the end of the day, that bill is taxed by the Nova Scotia Utility and Review Board for reasonableness. And the board makes that decision on whether the lawyer's accounts are reasonable, and that's what the landowner is entitled to, and that's what the lawyer is entitled to. So it's not a blank check where a lawyer can just take the claim and run with it and get their entire bill paid. That occasionally happens. It occasionally happens the other way, where the lawyer might have put $100,000 worth of time into a case, and the board says, no, you're entitled to 25. That 100 was not reasonable.
Mr. Pinio,
yes.
you're at 8 minutes now, just to let you know.
Okay, thank you. So I would support the Law Amendments Committee inserting into Bill 169 a provision that removes the regulation that was put in place on June 1. It's the expropriation costs regulation. And just to bring this full circle, the theory of expropriation compensation is that every landowner and every citizen in Nova Scotia pays his or her taxes. So if a road is going to be built, everybody has already contributed to that road being built. If a landowner's land is taken for the building of that road. If the landowner doesn't get full compensation, that landowner is contributing to the public work twice. And that follows through that if the landowner gets the compensation award for the value of the land and the damage to his or her business operations, and then has to, out of that award, pay their lawyer, well, they're still contributing back to the public work. And I submit that that is contrary to the reform legislation across the country, and I submit that it's a dangerous situation for Nova Scotia citizens who don't have the wherewithal to hire legal counsel and can afford to put that money out and not expect it back. So, thank you. Those are my submissions.
Thank you, Mr. Pinio. Questions? Ms. Chender.
Thank you very much. That reminded me of some of the better classes I took in law school, but was genuinely really helpful, because it is difficult as lay people to interpret this kind of specified legislation and understand the impacts that it has. So one thing, though, that really popped out is that your presentation was in sort of direct contradistinction to that of the municipal solicitor for HRM, John Traves, who came in with unbridled support for the bill and specifically liked the two provisions that you pointed out as being particularly problematic. And so I guess my first question, and I'm hoping the chair will give me a follow-up, is are these two provisions, and the change of venue to the Supreme Court and taking away the right to seek injurious affection where there's no taking, are those more advantageous to an expropriating authority than to a landowner? I mean, presumably yes. Would that?
Mr. Pinio?
I don't know. I'm asking.
Sure. I mean, putting both hats on, I don't see that there's any advantage to those claims being moved to the Supreme Court. And I, with the greatest respect to the judges that I appear before very regularly in the Supreme Court, I just feel that the specialized tribunal has that body of institutional and individual knowledge that that they're able to draw from the past to better serve both sides in that.
I don't see any other hands up. Supplementary to Ms. Chender.
Okay, thank you. That's helpful. I guess my follow-up question there, which is the question that I asked the solicitor, was whether you see any access to justice issues with that change of venue. And also just a clarification on the Tariff A or Tariff C, because I'm not up to speed on the civil procedure rules. Would the costs, that would be separate from their whatever reward that they got or didn't get, right? The cost would, this is just determining costs. So that 40 or 50% has nothing to do with the value of their land if awarded. It would just be the lawyer's costs. Is that accurate?
Mr. Pinio, we've got 2.5 minutes.
Sure. Yes, the costs award is determined separately, and it would be determined separately whether it's at the board or before the Supreme Court. Yeah. So it's the same numbers, just different judge or judicial body determining it. So.
Ms. Chender, do you have a supplementary?
I had just asked if there were any access to justice issues engaged with that change of venue that you would see.
Mr. Pinio.
Sorry. I don't see any access to justice issue with the change in venue. The access to justice will come with the costs, the tariff change. That will be a very important and difficult access to justice question. So, thanks.
2 minutes. Any final questions? Well, thank you very much, Mr. Pinio. Thanks for coming in. Would Dolly Mosier be here? Terrific. Ms. Mosier, if you would come forward to speak to the Bill 180, the Fatality Investigations Act. And Ms. Mosier, in case you missed it, it's a 15-minute window that you have, 10 minutes usually for presentation, 5 for questions, but you can choose to speak for 7 or 12, whatever works for you. So the floor is yours, Ms. Mosier.
Thank you. Good evening. My name is Dolly Mosier, and I'm the co-founder of Silent Witness Nova Scotia, an organization created to honor and remember women who have been killed by their intimate partners. Our organization has conducted workshops and presentations to schools, workplaces, social groups, various religious organizations, and have worked with families of domestic homicide victims. Our decision to launch Silent Witness in 2003 was by a group of service providers and community members to address domestic homicide, came after hearing the New Brunswick Silent Witness Project during Family Violence Prevention Week in 2004. While our presentation was underway, little did we know Cecilia Julian of Cape Breton was being airlifted to Halifax and later that night succumbed to her injuries from domestic violence. In 2005, we conducted extensive research on women murdered by their intimate partners from 1990 to 2006 and have recently updated our research to include up to 2018. Our research into those deaths show that 62 women have died as a result of domestic violence. Many of their stories have very similar indicators, and I personally have studied each one of their files and often use information from that research to better my work with victims of domestic violence, training of police and service providers, and educating communities. I've hosted conferences and learning symposiums on the topic of domestic homicide and have brought experts from across Canada and the US to speak on the topic. I sit on the Canadian Femicide Observatory for Justice and Accountability and have worked with several members of the Ontario Death Review Committee. I am here to speak to you tonight about the merits of a domestic homicide death review committee process for Nova Scotia. This is an opportunity for all of us to look closely at domestic violence cases with a view to prevention. We have a strong and important focus on responses after a tragic death, and this will give us vital information that will help to consider ways of preventing these deaths from taking place. A key benefit of these review processes is that they can bring together experts from within and outside of government to undertake a detailed review of the circumstances of a domestic violence homicide and to make recommendations to prevent future deaths in similar circumstances. These review processes offer an opportunity to better understand where and how response and support agencies and systems intersect and how they can better work together and can offer pathways for better interagency communication and coordination. Domestic homicide death reviews can reveal, for example, that at-risk families can be involved with a number of service providers across multiple sectors, for example, police, child welfare, and victim services. These systems and agencies have valuable information that can indicate the potential risk for further harm. However, in some cases, there is a lack of communication between these systems and agencies, resulting in a failure to implement effective risk management and safety planning strategies. The review process can also shed light on the barriers to supports and services that the victim and the perpetrator may have experienced. Many victims of domestic violence encounter barriers or gaps in service, particularly victims from more vulnerable communities, for example, immigrant and refugee communities, Indigenous and African Nova Scotian communities, rural, northern, and remote communities. A domestic violence death review can identify these barriers and gaps and form recommendations to address the issues. With these amendments, the legislation will allow public bodies and agencies to share personal information and personal health information to inform the work of a death review committee. Currently, that is not possible, so they are often working in isolation without the full picture of the circumstances that led to a domestic or to a victim's death. Death review committees can examine problems in education, training, and coordination of services that may be important to prevent domestic homicides. For example, a domestic violence death review can identify risk factors to help predict potential lethality and better inform risk assessments. This is critically important and aligns well with the work we have done in Nova Scotia to build a robust risk management approach with the Dr. Jacqueline Campbell Danger Assessments, which supports victims, and the Odera Police Risk Assessment, which capture risk for lethality. It is important to note that Nova Scotia has taken a step towards death reviews in other ways. In the year 2000, after the deaths of Lori Lee Maxwell and Bruce Allen George in a murder-suicide, the Chief of Police in Truro asked for an inquiry, as so many service providers were working with this family, yet none knew the potential for this murder-suicide to occur. As a result of that inquiry, recommendations set out by Dean Don Russell suggested to create an opportunity in these high-risk cases to share information. And I'm happy to say, since 2004, when the high-risk case coordination protocol was implemented, no deaths have occurred in any of these cases that have been identified as high risk. Again, though, those are only identified high-risk cases, which account for approximately only 3% of domestic files in Nova Scotia. Missing from these coordination tables are, for instance, health, border services, and some secondary service providers due to privacy issues that prevent information sharing. What we know is that many of the murder-suicides have had no previous interventions with police or service providers, but family members and co-workers often become confidants. As in the case of Catherine Darlene Eisner in May of 1994, both she and her husband shared concerns about the potential for violence in their relationship, but only with co-workers and friends and family. They were not on the radar of police or other service providers. This is information I use when teaching domestic violence in the workplace workshops to help co-workers identify and help victims flee the violence. There has been discussion about the confidential nature of domestic homicide death review committee process. For all the reasons highlighted, it would be important that learnings from committees be shared publicly, but this should not compromise the privacy of the families and their victims and their families. The lives of the deceased need to be honored, and the details of the tragic circumstances of their loss need to be treated with consideration and respect. In summary, the goal is future-focused on prevention and building a more integrated and effective response system such that they can work more effectively together to prevent future tragedies. The domestic homicide death review process will help us to understand and make recommendations on how family violence can be prevented and reduced. Thank you.
Thank you very much, Ms. Mosier. Questions from the committee, Ms. Adams?
Thank you very much for being here. I'm wondering if you have any idea of this, of the 62 deaths that you referred to. How many?
Oh, sorry.
How many of the victims had taken a restraining order out against the person who ultimately took their life?
Ms. Mosier.
Sorry, in those two particular deaths, there was neither. In the second death, as I said, the victim had no, she wasn't working with any service providers. They weren't on the radar at all. But in the case of Dean Don Russell, there were several police agencies, probation, parole, peace bond was applied for, and child welfare was deeply involved. But nobody knew of each other because of the privacy, so everyone was working in silos. And she was actually murdered on the day that probation was going out to arrest him. So,
any other questions? Thank you very much, Ms. Mosier. I don't think Patrick Sullivan is here. I know him to see him, so I don't think he's here. Is Dr. Leah Genge here? All right, well, I guess one piece of work we can do is deal with motions on Bill 175 and also 169. So, let's deal with 175, which is the Marine Renewable-energy Act. Ms. Lonis-Croft.
Yes. I move that Bill 175 be sent back to the House without amendments.
Any discussion? All in favor, please signify by saying aye. Aye. Opposed? Motion's carried. And then let's deal with Bill number 169, the Expropriation Act. Ms. Di Costanza.
So, thank you, Chair. I move that Bill 169 to be sent back. No. Okay. Yeah, no, we're going back to it, sorry. Bill 169, the Expropriation Act, to be sent back to the House without amendment.
Thank you. Any discussion? All in favor, please signify by saying aye. Aye. Opposed? Motion's carried. Thank you. So we have two witnesses. They have been contacted to ask if they would come earlier. I do think we have to respect the time that they were given. So we will recess to presumably 9:15. If they come earlier, stay close by and I'll call folks back if that's okay. So we'll adjourn for a few minutes. Thank you. Order, please. I'd like to bring back to order the committee to continue. We have two more witnesses. One has arrived, so hopefully our last witness will arrive a bit early as well. So we're back to Bill number 187, the House of Assembly Act. And Mr. Patrick Sullivan, President and CEO of the Halifax Chamber, has joined us. Mr. Sullivan, welcome. Our format here is a total of 15 minutes per witness, 10 minutes approximately for a presentation, for maybe 5 minutes of questions, but you can certainly go longer or shorter, but on balance we'll be at 15 minutes, and I just ask that you wait to respond being acknowledged by the chair. So I'll turn now the floor over to you, Mr. Sullivan.
Okay, thank you, Mr. Chair. Good evening, everybody. Thank you for welcoming me, I suppose, this evening. Didn't think I was going to be here this early, so I'm sorry I'm a little out of breath after running down the street from dinner at La Fresca, which was very good. So, my name is Patrick Sullivan. I am the President and CEO of the Halifax Chamber of Commerce. For those of you that don't know the Halifax Chamber of Commerce, we are a membership-based organization of over 1,700 businesses in the Greater Halifax area that represent over 65,000 employees. I do have notes, so I apologize that I'm going to read from the notes, so I hope that's okay. I wanted to be clear about the legislation. We have three concerns with the legislation as presented. It revolves for us, I know there are a number of changes in legislation, but it revolves for us about the increase in seats. So the Halifax, here's the concerns. The Halifax Regional Municipality, with currently 47% of Nova Scotia's population, should be effectively represented, and considering the population numbers and growth projections of Halifax, and when I say Halifax, I mean Greater Halifax, Halifax, Dartmouth, Bedford, Sackville, for the members. Halifax is underrepresented. It does not have voter parity at this time. That representation for African Nova Scotians and Acadians be entrenched in the current 51-seat House, and that the current number of MLAs, or 51, should not increase, and should in fact decrease, although we're not specific about that, to reflect the realities of our province today and in the future. So my points will address these three areas. According to the 2018 fiscal framework presented to Halifax Council from city staff, Halifax will reach 50% of Nova Scotia's population by 2022. If Halifax was to be effectively represented based on population, we should see 25 to 26 MLAs, but we currently have 22. This is not voter parity. In fact, following the population estimates, if the Commission increases the number of MLAs from 51 to 55, then representation should be 27 MLAs. It's our belief that Commission, and that would be the Commission that's presented the report and ultimately the legislation, must face the demographic realities of Nova Scotia and the projected future of Nova Scotia for the coming years. By 2022, Halifax will require 5 new MLAs to meet the population target by riding. Halifax is growing. Not only that, but when we look at population growth in Nova Scotia for 12 months ending June 30th, 2018, we see that Halifax is the only area that is growing at a significant rate. The province of Nova Scotia had a population increase at that time of 0.55%, provincially driven by an increase of 1.59% for Halifax. And of the 18 counties measured in that study, 12 of them have had a decline in population in the last 12 months. Halifax is the only area really growing, and it's growing for 2 reasons. If we look at immigration, 3,717 immigrants came to Halifax and 589 went to all other areas of the province. If we look at births versus deaths, Halifax had a net 825 births, and all other counties in Nova Scotia combined had a total of 1,793 deaths versus births, for a net decline in organic growth. Halifax is the economic growth generator for the province, providing 56% of GDP and 51% of our major project spending. We are advocates for voter parity, and we do not want to see our members across Halifax and Nova Scotia feel that they are underrepresented because of the district size and/or voter ratio. The Halifax Chamber and its members are in full support of providing cultural and linguistic representation for African Nova Scotians and Acadians across our province. We feel these groups can be incorporated without additional MLAs, either through the redistribution of current representation and/or through general representation. We did not feel it was our place as the Halifax Chamber to provide specific guidance on what those ridings should be and where those ridings should be placed. However, given the proposals provided by the Commission and ultimately those being adopted, we feel we must comment. We believe that in recognition of the cultural significance and contribution of these communities we recognize that the cultural significance and contribution of these communities is broader and should be ingrained within the broader culture of government and by all MLAs rather than expecting specific MLAs to represent those groups. We were quite surprised to see as simplistic a solution as we did, developed by the Commission with the additional seats in underpopulated areas and a return to essentially the protected ridings. Providing seats for Nova Scotians that represent an average of 7,000 electors disenfranchises the voters in average ridings. In addition, there is real concern that Acadian voices in the legislature will in fact be missed. There are 12,000 French first language speakers in HRM. If there's a real concern for Acadians, what about seats for Acadians in HRM? We still believe that with the MLAs in the province should not exceed 51 seats. But if we must increase seats when reviewing the electoral maps included in the Commission's report, we fully acknowledge we're in no way experts, but it seems that areas in Cape Breton and Southwest Nova could easily be combined while still respecting voter parity. Specifically, the additional ridings considered in the southwest of Clare and Argyll could be combined to provide the requested Acadian riding around Yarmouth and total approximately 13,000 electors, or very close to the average. The riding of Richmond and Guysborough could also be combined in some way to reduce the number of additional seats. As suggested, there will now be at least 3 ridings that will be well less than 60% of the average riding. All these ridings are deemed exceptional. In other words, approximately 5% of the ridings in Nova Scotia are now exceptional. This seems to completely disregard the guidance of the Supreme Court, which has provided specifics in the past around the Carter decision. In summary, we're very concerned with the Commission's proposed riding additions and the suggested additions in the legislature for many reasons. One, Halifax is currently underrepresented in the provincial legislature, and these proposals will not improve that representation today and will continue to get worse as time goes on. This proposal is in fact built for the past, not the future of Nova Scotia, with an increasingly urban population, which includes both African Nova Scotian and Acadian populations. Adding additional ridings in areas that have significantly lower population of electors harms the electors in other ridings. To quote the Supreme Court of Canada's 1991 case, reference Prov, or provincial electoral boundaries, bracket Saskatchewan, close bracket, effective representation entails relative parity of voting power. A system which dilutes one citizen's vote unduly as compared with another citizen's vote runs the risk of providing inadequate representation to the citizen whose vote is diluted. Where the unequal weighting of votes is not required to ensure better government, dilution of one citizen's vote as compared to another's should not be countenanced. So this is from the Supreme Court.
You're at 8 minutes now.
Oh, sorry, okay. If the Commission insists on additional seats, 3 additional seats are not necessary. Costs of additional seats have seemingly not been considered in the report. There may be a belief that taxpayers' funds are limitless, but adding additional seats have costs today and in the future. Our estimate for 4 new members is an additional $1 million a year to the Nova Scotia budget in perpetuity. These suggestions provided by the Commission and ultimately in legislation are not forward-looking, but rather looking to the past for today's answers. We strongly encourage yourselves to recognize the amendments proposed, do not recognize the realities of the population in Nova Scotia today or in the future. The reason the Commission was called was because of successful legal challenges. My fear is that further legal challenges will be forthcoming if voters are disenfranchised in this area. Again, dilution of one citizen's vote as compared with another should not be countenanced. Just in summation, we did a survey at our last Premier's Luncheon. We asked the folks who were there what they thought. I think many of you were in the room, actually. Of the 399 respondents, 35% felt the seats should remain the same. 48% believe there should be less MLAs. That is a total of 83% of respondents felt there should be less or the same number of MLAs. Thank you very much.
Thank you, Mr. Sullivan. We do have a question from Ms. Lonis-Croft.
I often wonder why the French foreign Protestants who came over in the 1700s don't have a riding. My ancestors. But I was very interested with your comments and ones that we haven't heard this evening. I wondered, did you do this presentation for the Commission? Twice. Did you get any response from them at all?
Just let me recognize you. Yeah, you can repeat twice if you'd like. You can say twice. Mr. Sullivan.
I apologize. We presented to the Commission twice, and the response from the Commission, I believe they recognized us, but given the terms of reference that they were provided, they did not see fit to adjust their recommendations.
Ms. Martin?
That was my question. Thank you.
Okay. Ms. Adams?
Thank you for being here tonight. And I can't recall the exact shift from rural to metro, the percentage over the last couple of years. For some reason, I'm recalling the number 12%, but I don't know exactly. And I'm wondering, do you know exactly what the shift from rural to metro percentage change in population has been over the last couple of years?
Mr. Sullivan.
I don't know the percentage, but I will tell you that Atlantic Canada is very unusual in terms of the population as it stands. In many other provinces of Canada, that shift took place in the 60s and 70s. So if we look at Ontario or even Quebec, the population is 80% urban and 20% rural in those provinces. Manitoba, 700,000 people in Winnipeg, 400,000 people in the rest of the province.
Ms. Adams, a supplementary.
Thank you very much. I'm wondering if you've spoken with the Chambers of Commerce from other provinces. I know the thing that I heard from constituents was they didn't understand why there was a need for more MLAs because they question our value anyway. But they did point out, for those who were aware, that in Ontario, one MLA is responsible for up to 110,000. So, there's an argument for why do we represent between 8 and 15,000 when, a similar MLA in another province represents 4 to 10 times more than we do. So I'm just wondering if you've spoken with other commerces from across the country and how they feel about this particular issue.
Mr. Sullivan.
I can't say that we've spoken about this in particular. We do and did look at other provinces when we did that survey. So Ontario was 118,000, for instance. In fact, the city of Halifax has only 16 councillors versus our current 22 MLAs. So the city of Halifax, if we look at electors, has approximately 20,000 people per councillor versus the average, what will be the average at about 13,000.
Any further questions? Thank you, Mr. Sullivan. You can get back to the press gang for dessert. Thank you. Okay, Dr. Leah Genge. All right, we'll have that presentation copied. All right, so we will need to adjourn for a few minutes and wait for Dr. Genge for 9:30, but we can deal with bill number 187. Does anyone wish to make a motion on bill number 187? Ms. DiCostanzo.
So I move bill number 187, House of Assembly Act, amended, to be sent back to the House without amendments.
Any discussion? All in favor, please signify by saying aye. Aye. Opposed? Motion is carried. Thank you. So we will adjourn until the arrival of Dr. Genge. order. I'd like to call the committee back to order. Our final witness has arrived. Thank you, Dr. Genge, for showing up a few minutes early. We've got just you to hear from on the bill number 180. And just before we get into it, our translator is downstairs, and I'm just wondering if the committee's comfortable with allowing our translator to leave before the end of the meeting. We're good there, yes, all right. Well, un grand merci pour notre travail. So we're done with the French for this evening. Dr. Genge, our presentations our time allotted is 15 minutes per witness. You have 10 minutes to make your presentation, although you could vary that if you wish, and then 5 minutes of questions. So a total of 15 minutes. You can talk for 7, talk for 12, talk for 15. I'll try and give you an 8-minute warning if needed. And the floor is now yours. Thank you.
Thank you. Well, thanks for staying so late and trying to fit me in. I don't have a formal presentation because this was kind of brought to my attention rather last minute, and having just flown in the middle of a busy clinic all day, so I'll do my best. To get by way of background, it may be valuable for you to know where I'm coming from with this. So I'm a family physician who practices entirely to serve people who are homeless, vulnerably housed, and marginally housed in the HRM, which includes a lot of patients that will be affected by this act. And in particular, I also do a lot of addiction work, so I have a certification with the College of Physicians, which probably a handful of us in the province have. And a large number of my patients are in and out of corrections, and so this type of work is of great interest to me. There were a few things about the piece, what I was able to kind of put together. First being that, so obviously, like the spirit of this amendment is, the investigations and making public, is all supported. I just was a little bit concerned about the piece that pertains particularly to people in incarceration or who are incarcerated. If I looked specifically at the section like 39E, when it talked about the members of the committee, when it explored issues related to domestic violence or cases involving children in the care of the province, that sort of listed, that was very, diligent to highlight that people with expertise in that field need to be involved. I didn't see that mentioned at all about people who are investigating cases in corrections. And the reason I say that is because since I've moved back to Nova Scotia 4 years ago, I've had significant difficulty accessing information around cases that I've been concerned about in incarceration. Healthcare that I am gravely concerned about in corrections. I'm having a lot of difficulty sort of accessing that and making changes to that, despite a lot of advocacy work, which is why I'm involved with the Prison Justice Committee. And I think that that's really important. The other thing that I've seen since moving back here is even within sort of the college, there have been big sort of shifts. There are a lot of people without expertise that make recommendations on addiction and things like this without really any background to support it, which has been kind of flabbergasting. And so I think that I would really want to see somebody, not necessarily myself, but somebody with experience in serving vulnerable and underserved people, as well as those with a lot of experience understanding about addiction. Because of what I'm particularly worried about is the overdose rates we have in corrections and also coming out, and the lack of addiction treatment that's happening in our facilities, the gross inadequacy of healthcare in facilities, for one, but in healthcare, in prison facilities, in jails, but the complete lack of a systematic addiction treatment. And subsequent overdoses, I think if you were to examine or overdose deaths in this year, you would recognize that a lot of them have happened just after people have been released from corrections, which is the highest risk for overdose. Yet we continue to not systematically sort of screen people for addiction when they're in for like drug-related crimes. and the arbitrary sort of rules and regulations by which methadone and Suboxone treatment are being used inside are very perplexing to me. So that's something that I want to be addressed, and now it's pulling up not my notes, but so my first piece is that I want to make sure that there's somebody with some specialty of understanding that's also involved in the committee. And the biggest piece, of course, so that would be one piece. The other thing would be the timeline around corrections, which I just sort of alluded to, is that so there are deaths in prison, there are suicides, there are homicide and sort of overdose-related deaths. But the deaths that I see most commonly are just out as once people are released with no care plan, either have been arbitrarily cut off of their opiate agonist therapy or not started, or just not continued. My cell phone rings every Friday at 4 o'clock when people are released from jail, because I don't mind people calling me on their cell phone to bridge their methadone or Suboxone. But if I'm not answering the phone, then these people are left to their own devices. They use and they overdose. And we've had at least 2 or 3 funerals that I've been to this year have probably been as a result of that. So it's a problem. And so I think when you're looking to capture deaths that are, because that's very much related to their care and corrections, and that is very easily fixed. And I think if we were to really seriously look at the opioid crisis in this province, we would first and foremost focus on corrections, because I think we could cut down on a lot of them. So I think that window needs to be open a wee bit, particularly if it's an overdose death. If they've overdosed and if it's within 2 weeks of their incarceration release, I think that their treatment within incarceration must be investigated. Must. I know of personally one family that I've been working with just recently. He overdosed this year after being released. I saw both his mom and his brother today, and I've been trying to file complaints. They've been trying to file complaints, and their ability to get health records has been really traumatic, even more traumatizing than finding his brother dead with a needle in his arm. So I think that piece must be considered, and that's why the expertise also needs to be involved in sort of these amendments. And then my final piece is, of course, the access to making these findings public. I think in the presentations today, they've already alluded to a few other cases with Clayton Cromwell and Jason LeBlanc and the patient that I saw, and I asked his family today if I could use his name, so Lyndon Brooks. And they all wholeheartedly ask for the same thing, which is that they want this information made public. Why? Because we have to make change, and we are trying to access records and information and making change with the inside, and it is not working. And these are people who have historically been mistreated. Their rights have been, these aren't people who feel like they have a lot of, advocacy rights to go. And, this is not somebody at a hospital making a hospital complaint. This is somebody who has been treated, and from what I'm hearing, rather inhumanely in our correction systems. And so what voice do you feel like you have? So that information must be made public, and I really don't think there should be an exception to it, because it's up to all of us to defend the rights of those people, barring some private information, of course, right? But families that have been through this would ask for that. In going through, the other piece that has just been brought to my attention is the access to health information and records with FOIPOP, and I don't remember the exact part of the number that we're referring to, but that we cannot access this health information, and that these things can't be properly explored and studied is, in what other situation would that be okay? If we're going to be treating inmates and people who are victims of poverty and committing crimes and stuff that are related to all kinds of things that probably a lot of us in this room couldn't imagine, if we can't treat them with the same equity that we would want ourselves, and our own information and our own health systems to be held accountable, then, I just don't think we're going about this the right way. So that's all I have to say. Sorry it's fragmented. I just was putting a 4-year-old to sleep, so I almost brought bedtime stories. So
thank you, Dr. Genge. Ms. Lonis-Croft.
Thank you, and thank you for your presentation and coming this late. Being a parent and being out this late isn't isn't the best situation, but anyway, I appreciate you coming. You used access a lot and we heard before from other people who are here as witnesses. So do you think it's our privacy laws that are too stringent, or what do you attribute like the challenges for access, like to medical records, and like who should have access to these?
Ms. Grange. Dr. Grange.
That's okay. So I can't comment in a lot of detail about the privacy laws because I am not a lawyer and I don't know them in detail, so I wouldn't want to overstep in any way about that. You know, I think medical records, you know, are confidential for a reason, and they should be, you know, protected in that way, but we all have the right to our own information. And if you know, and so if something catastrophic happened to me in hospital, and so then my next of kin or people who wanted to explore that, then that would be appropriate. And I think we need to treat these the same way that we would other information. I don't understand why it's kept separate. Does that answer your question?
Ms. Lonescroft.
So like say somebody was embezzling money from the deceased, there would be a higher investigation, or information would flow easier, or is it because it's health records? It's
Dr. Genge.
I don't. So you mean with respect to health information within corrections? Yeah, I don't know why the access is so tricky. Actually, because from my understanding, I mean, any privacy, you know, from a patient-doctor confidentiality piece should be treated the same as it would be in my office or in the hospital, wherever I'm seeing somebody. So even as a physician, when I'm trying to get records and such for patients, it's not easy. And you would think it would be, because it's the health authority who runs, you know, who sort of runs healthcare in our provincial jails. But it's not. And our ability to talk to each other doesn't happen. It's not at all. Me getting a discharge summary from somebody in corrections doesn't happen in the way that it would for someone in the hospital, even though they're both sort of NSHA-run facilities. And I don't understand why that is. You would think that if we're all under the same, then it would be easier, but it is next to impossible. It's also next to impossible. People get discharged without life-saving medications, without psychiatric medications. They get discharged without methadone and Suboxone. Sometimes they'll get discharged if they're on insulin or something. They'll be given a week's supply, and good luck finding a doctor to fill that for you. But, you know, methadone and Suboxone are never, which are the opiate agonist therapy treatments for opiate use disorder, are never bridged. If this were any other life-saving medication, if somebody was, say, on their HIV treatment or Hep C treatment or on chemotherapy and were discharged and their medications weren't being continued, we would be in like public uproar. And actually, these are life-saving medications, and the risk of people dying without those when they get discharged is phenomenal. The highest risk of overdose for somebody on methadone and Suboxone treatment, other than the initial days that we're titrating them when we follow really closely, are after discharge from incarceration, and that literature is enormously clear. Yet, and people get released on a Friday without any medication, are expected to white knuckle it through the weekend and try not to use and try not to unintentionally overdose. With drugs laced the way they are, with fentanyl, that likelihood, you know, it's Russian roulette, right? And people also lose their tolerance too. So if they go back to using the same amount that they were using, I mean, it's very fatal. But this is information. I mean, we treat prison releases in opiate use disorder treatment clinics across the country with like high priority because the risk of death is so exceptionally high. Yet people are just released without anything, you know. And as I say, if this were any other life-saving medication, if this was any other group of people, we would all be upset about it. But people who, you know, have been incarcerated are treated differently. They're stigmatized because of that. They're stigmatized because of poverty, because of their drug addiction, and, you know, because of the crimes they have to do to sustain the chaos that they're living in, for the most part. I mean, there are other crimes, obviously, but, you know, and the healthcare and you know, I work at I'm the only physician for the Mobile Outreach Street Health Clinic. We are the clinic that serves everybody who is mandated to serve everybody who is homeless and marginally housed in all of the HRM. I'm the only physician. I get 12 hours a week from the province. And we have one NP and one nurse who's not even full-time, and we serve all the shelters. And we go in the woods when we have people who are living out in the woods in Bayers Lake. Like, our team is the people who are seeing them, and yet, it's not. We're it. Like, we're seeing everybody who's being discharged to the Metro Turning Point, and I can't even get a point of contact. I can call the nurses, and I bug them all the time, and they're lovely inside, but there's no formal process. And we wonder why people are unwell and things are happening when they get released.
We've only got a few seconds left. I've got Ms. Adams. Ms. Adams?
Thank you very much, and I'm sorry we don't have more time to talk, because I want to thank you very much for all that you're doing, because I'm sure you give way more than what you're allotted. The question I had asked earlier, and so I wanted to ask you again, is if somebody, all Nova Scotians have the right to have access to their medical records. So if somebody was incarcerated and they happened to go to the infirmary for medical tests, do they have the right to apply for their medical records just like anybody else who's not incarcerated would have the right to apply? And will they be given copies? And if somebody should pass away, can somebody in the family have the right to ask for those records?
Dr. Jen, again, I'm going to ask you to answer in 30 seconds.
Yes, they should have access to their records. Do they always get copies of it? Nope. Do they have difficulty getting it? Absolutely. For next of kin, it depends on who the family member is. And if it's being established, so if they have a will, which none of my patients do, and they say who their next of kin is, then they would have access. If not, they have to go to legal aid and establish that, and then they can apply. Lots of steps. That's my understanding.
We're out of time. I'm going to give Ms. Chender the last question of this long evening, and Ms. Chender.
Thank you. So I really appreciate all of your comments. Thank you. I guess right now there is no death review committee established for people in corrections. And so this is what we've been hearing some presentations about tonight. All of those things that you spoke about when people are released, we know are also issues when people are imprisoned. So their medications get cut off, they have no access, their medications get changed. So I guess my two-part question to you is, does that also pose a risk, at times a fatal risk? And do you support the establishment of a death review committee for people who die in the custody of the province in correctional facilities?
Dr. Chen.
So the first part is, so yes, it absolutely poses a risk, and a lot of the rhetoric people, they talk about all the overdose deaths we have and the drug trafficking. Well, when people are suffering, if you treat people's addiction appropriately, I wonder what would happen with the drug trafficking side. There's always going to be drugs in prison. I mean, there always has been. I mean, why are we so alarmed about that? But would people be seeking opiates and trying to cheek their Suboxone and share it if they didn't know nobody was withdrawing down the hallway and would pay them a ton of cash for it? Then no. So yeah, there are real fatal consequences. There are also people who I have patients who have never injected drugs. And had been on, they were maybe taking oral opioids, been on Suboxone, went inside, had their Suboxone cut off, and they started injecting drugs in corrections because they were withdrawing and not being treated. Huge risks to people and risks for overdose inside as well as when they get released. Would I support a public inquiry? Absolutely, into every death that happens in corrections or in overdose deaths that are within sort of 2 weeks of their release, and that must be made public. The barriers, these people have enough barriers in front of them. We do not need to make that process more painful and more traumatic than it already is.
Great. Well, thank you very much, Dr. Jen.
Thank you. Thanks for your time.
I'm sorry I'm having a tough time with your name at the end of the long night. Thank you for your presentation. We went a bit over, but I think your message was very important and it added to the discussion that we had earlier this evening. And I'm sure other members may want to talk to you after this meeting or at another time. But thank you very much for your presentation. All right, members of the committee, we have to deal now with Bill number 180. Ms. Chender.
I'd like to recommend two amendments to the committee. The first can be found on LAC NDP-1, which I think is being handed out now. You might as well hand out both of them. The second will be on LAC NDP-2. But while you're receiving them, I will just say that I think this last presentation was a perfect segue into both of these amendments. But this one simply says, as we've been hearing all night, that if we're going to the difficulty of amending the Fatality Investigations Act to include the death of children who are in the care of the province and the victims of intimate partner violence, it's almost kind of beyond credulity that we would not also include the death of people who are in the care of the province in incarceration, in prisons. This particularly specifies in correctional institutions such as a jail, a hospital or facility as defined in the Hospitals Act, as an inmate, so the East Coast Forensic, for instance, or an involuntary patient within the meaning of the Involuntary Psychiatric Treatment Act, or an involuntary resident in a healthcare facility, so that would probably refer to places like Mount Hope. Just like children are in the care of the province, these are also people who are in the care of the province, and one death is one death too many. And we've heard now from several presenters how difficult it is to get information of any kind about those deaths, even without an investigation. So at the least, we should have an investigation. Now, to properly move this motion, do I have to read the whole thing?
I would suggest yes.
Okay.
I mean, obviously this could be dealt with at Committee of the Whole.
It could be, but this is the Law Amendments Committee. We had several presenters asking for these specific amendments, and so I think in keeping with our desire to have an open process where the public contributes, we have decided to move these based on what we've heard.
All right, make your motion, please, and read the
okay, so
document.
LAC NDP-1, page 1, subclause 1, sub 1, proposed clause 2, sub 1, sub CA, lines 3 and 4, strike out or Child Death Review Committee established under Section 39D and substitute the Child Death Review Committee established under Section 39D or the Adult Death in Custody Review Committee established under Section 39E. Page 1, subclause 1, sub 2, proposed clause 2, sub 1, sub DA, line 2, strike out or 39D and substitute 39D or 39E. Page 2, clause 3, add the following after clause 39A, sub A. B, death in custody means the death of a person 19 years of age or older that occurred while the person was 1, detained or in custody in a correctional institution such as a jail, penitentiary, guard room, remand center, detention center, lockup, or any place where an adult is in custody or detention. 2, an inmate in a hospital or facility as defined in the Hospitals Act. 3, an involuntary patient within the meaning of the Involuntary Psychiatric Treatment Act, or 4, an involuntary resident in a healthcare facility. Page 2, clause 3, proposed section 39A, renumber proposed clauses B to D as C to E, and change cross-references accordingly. Page 4, clause 3, add the following after section 39D. 39E, sub 1, there is hereby established an adult death in custody review committee for the purpose of A, reviewing the facts and circumstances relating to deaths in custody, B, providing advice and recommendations to the minister regarding the prevention and reduction of deaths in custody, and C, performing other duties and functions as prescribed by the regulations. Pages 4 and 5, clause 3, renumber proposed section 39E to 39K as 39F to 39L, and change cross-references accordingly. I so move the amendment.
There's a motion on the floor. Is there any discussion? Ms. Lonescroft.
Thank you, and I thank you for this and the work that has gone into it. I myself need time to digest this, and I would hope that this would come forward in law amendments, not law amendments, sorry, in Committee of the Whole House. And I would really like to deal with this in the Committee of the Whole House, where there'll be more discussion and by a variety of people as well, and give us time to go over these important changes myself.
Any further discussion? Would you like to vote on the motion? Yeah. All in favor of the amended motion as read out by Ms. Chender? Opposed? Nay. Motion is defeated. Ms. Chender?
Thank you, Mr. Chair, and I will say, catching me at the end of a long day, but you know, I of course will propose these and probably in more detail at Committee of the Whole House. However, being a inveterate proposer of amendments to things, as my colleagues will know, we don't get very far very often with these amendments because the government tells us that they don't have time to consider them. So we're giving you time. You've heard these presentations, you've seen these. As I say, there will probably be more detail and perhaps more of these, but I would really urge my colleagues, particularly on the government side, to do as you've suggested and to take them under consideration. This second amendment deals with, I think, what was referred to in one of the presentations as the open court principle. So as we heard very forcefully, these committees, such as they exist and such as we are proposing them to exist, serve very little purpose if their findings are not made public. And so that's essentially what this does. It would bring a positive change. I think it would influence policy positively, but most importantly, I think it might help bring closure. And I think we've heard a lot about the individual experiences of families and communities today, and so that's what this is aimed towards. So I would move a motion that page 4, it's on LAC NDP 2, page 4, clause 3, proposed section 39G, delete subsection 4 and substitute the following subsection. Sub 4, a committee shall make the report publicly available within a reasonable amount of time following the submission of the report to the minister. Page 4, clause 3, proposed subsection 39G, sub 5, line 1, strike out notwithstanding subsection 4, where, and substitute where. Page 4, clause 3, add the following after section 39G. 39H, sub 1, the minister shall annually prepare a report on the actions and findings of the committees during the preceding fiscal year and make that report publicly available. Sub 2, the report must include any actions the government has taken during the preceding fiscal year in response to the findings or recommendations of a committee. 3, the minister shall table the report in the House of Assembly within 15 days after it is completed, or where the Assembly is not then sitting, file it with the clerk. Pages 4 and 5, clause 3, renumber proposed sections 39H to 39K to 39I to 39L and change cross-references accordingly.
Thank you, Ms. Chender. There's a motion on the floor. Any discussion? Ms. Lonis-Croft?
Again, I appreciate the work that you put into this change sheet and your recommendations. But again, I would like more time, and I think other members of our caucus would like more time to think about this. So I would like to see this brought to Committee of the Whole House.
Thank you, Ms. Adams.
Thank you. For the record, I just want to state that we would like the opportunity to take it back to our caucus members, and so we'll be abstaining from the vote, but that's just out of respect for our caucus members to allow them to have a look at this first.
Any further discussion? All in favor of the motion, please signify by saying aye. Opposed? Nay. Motion is defeated. Did I say motion is carried on the last one? No? Okay. Motion is defeated. Well, that concludes all amendments. Oh, sorry. Yes. Thank you. Ms. Lonis-Croft.
Yes. I move that Bill 180 be sent back to the House without amendment.
Any discussion? All in favor, please signify by saying aye. Aye. Opposed? Motion is carried. That concludes the law amendments. Thank you to all the members of the public that shared their expertise and information to the committee. Thank all the committee members for a long meeting, and the meeting is adjourned. Thank you.